But I can what I could do is I could call Mr. Bradley and then I can bring it back.
Exactly. I think you can always recall them. We can ping pong back and forth if we need to based on hearsay issues, but at least we can use this time until Mr. Partridge chooses to join us.
Is he on the Zoom by chance?
Hi, everybody. I'm coming on a little early today so we can watch this ridiculous hearing where
All right, so
the people in the RICO case are trying to get Fani, Willis, and Wade disqualified, have the whole case thrown out, saying they had a personal relationship before it started, and it was to raise money and all this kind of stuff. Here's the problem. They're having trouble getting witnesses to show up to prove that there was a relationship earlier than said. So right now there's a whole lot of, can you get hold of this person? Can you get hold of that person? Oh, this person isn't answering their phone. This person's going straight to voicemail. Oh, this person doesn't want to be on Zoom. This person, it's a mess. Hello, Sean. Hello.
Is someone getting Mr. Bradley in?
Yes.
Is someone getting Mr. Bradley?
Oh, the sheriff's didn't go. Okay.
Oh,
Sorry.
this is
Normally
hysterical.
Sorry. Are the sheriffs, when I call a witness, will the sheriffs not
Good
sound for
morning,
them?
Tim. Good morning.
I don't know if they're going to know where they are.
Yeah, lady,
So
this
I think
is
it'd be
hilarious.
best
I
if
agree.
maybe someone
Hello,
from your
Debbie.
team.
Hello,
And they're not going to know what they look
Rebecca.
like either.
Hello, Amy.
Sure.
Hello, Kelly.
He's
Hello,
up.
Kelly.
Yeah.
Hello, Maria. Oh, Mayra. I'm so sorry. Hello, Cherry Bomb. All right, this is comedy gold. All of their witnesses just went poof. I'm getting ready. So this is also a getting ready with me, I guess. Hello, Dixie. Hello, Rebecca. Hello, Marianne. Hello, Heather. Hello, mother of three. Oh my gosh, this is good. Yeah, this is good stuff. This is good stuff. Oh, the hilarity. Oh, jocularity. Yeah, this is just. Heather's asking what happened so far. Oh, the people who are trying to get Willis and Wade kicked off the case, get the case dismissed. All of their witnesses went poof. And can you get hold of this person? Can you get hold of that person? Can you get hold of this other person? Can you? No. This is going to voicemail. This person doesn't want to be on Zoom. It's fantastic. Oh, wow. Wow. A whole lot of nothing. Exactly, Rebecca. Good morning. So anyway, I just thought we could enjoy this because Trump's in the New York case. He's in New York right now at that case. The hearing about the criminal case, and news is that the Bragg Stormy Daniel case, criminal case, starts March 25th. Jury selection starts March 25th in New York. And Trump that is the first criminal trial of an ex-president in our history. The judge has ruled that this morning that the trial starts March 25th. And Trump has to be there every single day of that trial. Oh my gosh. Hello, Dixania. So I know what this is. Art Maker Forever, is Trump there? No, he's in New York. And Joe's asking, I don't know what's going on here. Crickets, because here, let me write it. Let me put it in a banner underneath, because this is just glorious. Let's see, what would this be? This would be the Georgia Wade and Willis dismissal hearing. There's one person here now.
I do. Terrence Bradley, Terrence Bradley, Bradley.
Your Honor, as Mr. Wade's counsel, before we start, we would request the chambers to talk about attorney-client privilege before we.
Why does that need to be in camera?
Doesn't necessarily, well, there's statements that could be made, it could be prejudicial, depending on whether they were covered or not, whether he's gonna break the.
So at the time a question is asked that you think implicates some of those statements, object, and we'll handle it.
Thank you,
Merchant.
Judge.
Just on behalf of Mr. Bradley, and I apologize, this is not our proceeding, but it might be helpful to have a brief sidebar as opposed to something in chambers, at least so that we could let the court know our position rather than having to restate it repeatedly.
And Judge, I've carefully crafted my questions to avoid any privileged information. But if they think that I'm invading that, then I welcome an objection and I'm happy to address it.
Let's see how it goes. And again, Mr. Bradley, I'll ask if you can just give a pause in between each question to allow counsel the opportunity to object before answering.
Thank you, Judge. Was the witness sworn or do I need to swear the
I
witness?
believe he
Okay.
was.
Great, thank you. I'm sorry. Good morning, Mr. Bradley. How are you?
Good morning.
Not happy to be here, I'm assuming.
I am not.
I understand. Thank you for being here.
Wasn't by choice.
Right. You were subpoenaed to come and testify in this case.
I was.
Okay. But you and I have spoken previously about relevant facts surrounding Mr. Wade and Ms. Willis's relationship.
No, we have not.
We have not. We've not texted about those facts.
Through a third party, you were given some information. You and I shared text. Our text were more so about my health, more so about if I was okay with what was going on, that I would not be, whether or not I was going to be subpoenaed or not, and that emphatically I would not have been sitting in this position as being called as a witness. So that's what my text chain show. So no.
That we've never talked about Willis and Wade having a relationship.
Not directly you and I, no. We talked about my health.
Okay.
We talked about, as I stated before, other things, but not this, no.
Okay. Did you text me about Wade and Willis taking many trips together?
I'm gonna,
I object. Well,
Mr. Brown,
so-
there's been an objection.
one, I'm gonna object as it relates to attorney-client privilege. Two, I'm going to object because I haven't seen the text message that she's attempting to impeach the witness with. And two, he's made all of his representations is that he's had zero communications as it relates to the issues that Ms. Merchant continues to ask about, and that the only information that she has from him is through a third party, which would be hearsay.
Ms. Merchant.
Judge, it's not hearsay. We've had these conversations. If I need to take the stand, I will. If I need to put my phone into evidence, I will.
So the first objection was to privilege on behalf of the state.
Oh, I'm sorry. I did not respond to that.
Sure.
Thank you, Judge. Privilege is only communications that are made in furtherance of legal advice. There's been no showing that whether or not they took a trip to California or took a trip, or that Mr. Bradley and I talked about that, either in person or by text, that's privileged. I'm not asking for any communications that Mr. Wade might have made to Mr. Bradley in furtherance of any legal advice.
All right. And Mr. Abadi, I believe as the one asserting privilege, it would be your burden to show the necessary foundation there. Is that something you want to voir dire the witness on or take up here on this specific question?
Well, no, I'd also object to foundation grounds. She has not provided any foundation that he would have any knowledge of what she's requesting he answer. His answers were he had no knowledge. And now she hasn't laid the foundation in order to continue to ask the same question over and over.
Ms. Merchant.
Judge, on behalf of Mr. Bradley, we do object. This falls under the privileges afforded under 1.6 of the rules. And the attorney-client privilege is not something that Mr. Bradley can waive. Only Mr. Wade can waive it, regardless of any information or communications being proffered by the claimant Mr. Wade would have to waive them for Mr. Bradley to continue to testify about any of this relationship until it's been established when that privilege should have begun.
Sure. And so far, though, I haven't heard anything about a relationship, about an attorney-client relationship, about a privilege ever attaching. And I think that's going to need to be established before we can actually determine the scope of it and whether this falls inside or out of it. So I think either Ms. Merchant can take the lead if she wants to, but my understanding was that generally has to fall on the person who's asserting the privilege.
Except for the attorney is not authorized to violate that privilege, or else he has in fact violated the bar rules, which we have an opinion regarding from someone in the State Bar of Georgia.
All right.
That's why I thought perhaps the sidebar might be important rather than my interjecting.
Well, I still want to kind of see how we can go. So, Ms. Merchant, it sounds like you're going to need to lay a little bit more foundation to see whether this actually is going to fall under privilege or not.
That's not a problem, Judge. And what I can do, I was just told that Ms. Yurdy's in the waiting room. But I can, if the state wants to read my text, if Mr. Bradley wants to read them to refresh his memory, I have absolutely no problem with that. I have my phone here and they're welcome to do that. But I'll talk about some other things. And then maybe if they're going to have a lot of objections to privilege and hearsay, what I can do is I can lay a foundation with Mr. Bradley, get him off the stand, put Ms. Yurdy up, and then Mr. Wade, so we can get through the privilege issues. That might make the most sense. Thank you. All right. Let's talk about something not controversial then. When did you and Mr. Wade first meet?
Probably 1998.
Okay. And did you all have a law firm together?
We did.
Okay. When did that firm start?
Probably, I think it was 2010. We started exclusively working together as a firm, operating as a firm.
Okay. And were you all actually incorporated as a firm?
Not initially, no. He had, when I passed the bar and I hung a shingle in 07, I think he had been practicing a few years prior to that. He had his own firm. We had two separate firms.
Okay. At some point, did you all incorporate though together?
We did.
Okay. Do you remember about when that was?
I do not at this particular moment, no, ma'am. I'm sorry.
Okay. Do you remember if it was administratively dissolved?
I've been made aware that it's been administratively dissolved. Yes, I left the firm around 2 years ago.
When did you leave the firm?
August of 2022, I think it was.
August of 2022. Okay.
Or it was either August or September of 2022.
Okay. August, September. Let me make a note. So in October 2019, were you all incorporated as a firm?
I think we were, maybe.
Okay.
Yes.
And when Mr. Wade filed for divorce November 1st or 2nd, 2021, were you all incorporated as a firm?
We should have been. I'm thinking that we were. Yes, ma'am.
Okay. When did Mr. Wade come to you to file the divorce action in Cobb County?
That's privileged information.
The timing and the beginning of the privilege, I don't believe that is overruled.
So the timing was around 2018.
Okay.
And it was probably December of 2018. I remember it specifically because I was building a house. And I noticed that he wasn't wearing his ring. I asked him about it. I had invited him to the house because I was having not a housewarming, but people over. And he wasn't wearing his ring. I inquired about it. From there, we discussed what would happen. And we discussed the divorce and what would happen.
What would happen with the divorce?
What would happen over me representing him for the divorce and when he would want to do it. Yes.
When did he retain you?
Well, my memory would be 2018
Okay.
when he consulted with me about the divorce and told me what he would like to see done and when he wanted to do it.
Do you know when Fani, Willis, and Nathan Wade met?
Specific dates, no. I know it was sometime at a conference.
Municipal court conference?
Correct.
And October 2019, if it's been represented in the state's pleadings before, that's when they met. Does that sound familiar?
If that's what they're saying, then absolutely. I know it was at a conference in 2000. I mean, it was at a conference. If you say it's 2019, I'll take you at your word.
Okay. So it was what you're sure of though, is it was at a municipal courts judges conference
Yes.
when they were both municipal court judges.
Yes.
So it's fair to say, since she became the district attorney, she was no longer a municipal court judge. So it had to have been before that.
That they met?
Yes.
Yes.
And he was teaching a class at that seminar, as far as you know.
I'm gonna object as to leading at this point. She has him on direct.
Was he teaching a class at this seminar?
To my knowledge, he was.
And was Miss Willis, to your knowledge, attending this seminar?
Your Honor, I'm gonna object. He has no personal knowledge. He wasn't present at the municipal court training.
But they put it in their pleadings. Like, we are going to be here all day.
We are gonna be here all day.
All right. If you can establish that he would have some personal knowledge, then that's a fair question. So if you just need to preface it with that, then that's fine.
Thank you. Are you aware of when their romantic relationship began?
Your Honor, I'm gonna object. That's relates to privilege. She says that he began representing Mr. Wade in 2018. He met Miss Willis in 2019. That's clearly within the bounds of attorney-client privilege.
I think there's
Note that.
understood, Mr. Abadi. So I think, Ms. Merchant, you need to qualify that question.
Thank you. I'm not asking you to tell me what Nathan Wade told you in furtherance of legal advice. Okay, so I want to be very clear. If he told you something asking you legal advice, I'm not asking you about that. I'm asking about what you observed, what you saw, and what you knew outside of what he told you when he was specifically seeking legal advice. Okay.
This is too far afield. I apologize. I object again on behalf of Mr. Bradley. He's asserting that there was an attorney-client privilege associated with this case under Rule 1.6. For him to draw any inference, make any statements, or any other proffer of information after this relationship began between attorney and client in December of 2018 would be improper, and he would in fact be violating the rules of ethics associated with the bar license.
So the way the question was phrased was just saying, what did he personally observe outside of the relationship, not involving communications? How does that fall within attorney-client privilege?
Honor, whether we like it or not, when we have a client, there are a number of items associated with that relationship between attorney and client that come within your purview and that lead you to further action, lead you to further investigation, further questions, develops your strategy. We can't talk about Mr. Wade on any level. It would be inappropriate. The divorce was filed sometime thereafter. During that entire interlude, any of these issues could in fact have formed the basis for their relationship to remain privileged.
Ms. Merchant?
Judge, his observations are not privileged. That's not what the privilege law says. And I can read you the attorney-client privilege attaches where, and this is the law, this is the rule. There's an attorney-client relationship. The communications in question relate to the matters on which legal advice was sought. And the communications have been maintained in confidence, and there's no exceptions to the privilege. First, on number two, the second prong. This was not in furtherance of legal advice. That's not in furtherance of legal advice. What he witnesses as a human being is not in furtherance of legal advice. Unless, I mean, and if he witnesses them together, it would get rid of the attorney-client privilege because Ms. Willis is there. Additionally, though, exceptions. We can go all day about exceptions to this. Fraud to the court, that's an exception. Mr. Wade, we contend, has filed a false affidavit with this court. That is fraud to the court. If this witness has direct knowledge that that is not true, then that's an exception to attorney-client privilege.
All right. Ms. Merchant, if you could re-ask that question again, qualifying it as, if it's, I think you qualified it as anything that outside of anything he learned or was told as a result of his representation. It was just any observations he made, which in my mind, as you phrased the question, would have included before December 2018 when this first consultation occurred. I think if you can go step by step, we can handle this.
And Judge, I would just ask permission. We gave the state notice under 611 that all of these witnesses do not want to be here. They are adverse witnesses.
I understand.
Yes, so I'd like to have leeway to be able to cross them. Thank you, Judge. All right, Mr. Bradley,
Yes, ma'am.
in, you have knowledge that their relationship began in 2019.
I do not have knowledge, but again, I have consulted with the bar as late as yesterday at 4 o'clock. I am not here to,
Your testimony is that you do not have independent knowledge.
I cannot, I was advised by the bar that Rule 1.6 of confidentiality applies and that I cannot reveal anything that I saw or learned. And that if the court is asking me to do that, that an immediate certificate of review should be asked. And so I'm not here to misrepresent to the court or to say anything inappropriate or anything. I am here because I also have a law license. And I'm not trying to lose that.
And so, Mr. Bradley, can you finish that thought? As saw or learned, just period, without qualification whatsoever?
Judge, I'm going to refer to what I was told by the bar, that Rule 1.6 of confidentiality applies, and that I would be asking for an immediate review by the Supreme Court.
Sure, but applies to what?
Any communications is what the person at the bar told us.
Any communications? So like
He did not
if you
qualify.
talk to Mr. Wade, that's covered?
Well, Judge, I don't know. He didn't go into those specifics, but this is what was told. I was sitting there with my attorneys, and this was what was told to us, to state that Rule 1.6 applies. And we gave them the scenario, and this is what they told us to do. And this is what I'm doing at this particular point.
Judge, and we have no knowledge if the bar was aware of the affidavit that Mr. Wade filed, but that significantly changes the privilege. He waived the privilege when he put that in the affidavit, so that's one of the reasons I wanted to call him. That's a waiver. He put the relationship in the when the relationship started and put the relationship in his affidavit. He put a lot of information in that affidavit that would waive certain amounts of privilege. So he disclosed this relationship. So basically what we've got is we've got Mr. Wade being able to say what he wants about this relationship, but then we're not allowed to ask questions to qualify that. So that's not how it works. They either get to admit it or they don't. It's either privileged or it's not.
We're just talking about a relationship, though. How does that open the floodgates to anything he's ever told an attorney during representation?
It doesn't, and I'm not asking him that. I'm asking for his knowledge. They were law partners, and as I go through the questions, I think he has knowledge of things that is not something that Mr. Wade specifically told him. I also think there's a fraud exception to a lot of this, even if there was a privilege, but I don't think there was for most of it.
Your Honor, but he's already
True.
represented that he has no knowledge about that.
I don't think we've actually gotten anything to that extent yet. I think we're still making our way through it, which is, I think he's taking the position that he's not willing to share anything Mr. Wade ever told him, period. Which that's a broader representation of attorney-client privilege than I've ever heard. And I think that's what we're trying to parse out, is if the relationship starts, I've never heard anything that said everything before that point is privileged. Do you have something that I should know? Yes, sir. That's fine.
These questions aren't being established. It was 2018, December. The last question was directly related to a point in time after that, during which the relationship attorney and client would have been already established. He has an opinion from the State Bar of Georgia that he's going to be required to testify. We need to be ordered by the court on any of these issues. And Judge, I understand how delicate this is. You can phrase it in 1,000 different ways to try to make him say something, but you can't unring a bell that he puts out into the universe where he has violated that privilege. We're going to get to go back 6 months from now and say, oh, well, we shouldn't have said that. It's not acceptable. It violates hundreds of thousands of relationships in this state that we rely on in order for the justice system to function. This is an attorney-client privilege issue. We've done all the diligence we can as far as looking up the relevant laws, the relevant information. We do not have a waiver from the client. The client is present. Whatever
There's no question why we're not barreling ahead is because I recognize the privilege. What we have to determine is actually what that privilege, the scope of it, and when it started. And I don't think we've even gotten close to that yet.
Judge, I thought December 2018, Mr. Bradley testified directly that is when the retainer and the divorce proceedings were beginning. The issues being brought up by the state have to do potentially, if I've been.
So we have a starting point,
Correct.
but does that necessarily foreclose anything from that point onward? If they started talking about something else entirely.
Divorce, of course not, Your Honor. But during the pendency, it would absolutely curtail that, especially as it has to do with observations, attendance at functions together, or other realizations that Mr. Bradley came into during the pendency of his representation. And to parse it out would put Mr. Bradley in an untenable position because his reputation means everything.
Okay, Mr. Sadao.
Your Honor, I think we're talking about two aspects of arguably the attorney-client privilege. There's the attorney-client privilege, which is controlled by case law and statute, which deals with communications and furtherance. I don't hear that being the objection. The objection is that there are confidential matters under 1.6, which in some form or fashion mean that once you start a relationship with attorney-client, that everything from that point on is confidential between the two of them. There's no such case law in Georgia that deals with confidential information of that time. Attorney-client, yes. Confidential information, no. And I believe what's being argued by counsel for Mr. Bradley is that he has received, of course, we don't have anything in writing, but he's received some oral advice that under 1.6, confidential matters cannot be gone into, which is, according to them, everything that occurs between Mr. Bradley and Mr. Wade from 2018 forward. There's no such law that protects such confidences, only communications made in furtherance. And if I'm mistaken, I apologize, but I think what we're being told is I don't have to say anything at all about Mr. Wade once I have an attorney-client relationship with him, because it would be deemed confidential. And if it's deemed confidential, I can't talk about it. And there's no such case law to that effect in Georgia. There is no bar rule to that effect. The only thing the court has to do is say, are we talking about attorney-client privilege or pure confidences or confidential information? And once you decide it's confidential information, you ordered Mr. Bradley to testify, and then it's up to his counsel to decide whether he wants to have his client held in contempt after you've ordered him to testify.
And Judge,
That's an overstatement. We have not said that he can't testify to anything. The specific question on the table is, what observations do you have between Mr. Wade and Ms. Willis from that point on? Now, they, the defense and their teams, have made an allegation of some impropriety. That same impropriety could be related to a divorce proceeding on every level. We're not here to say we're not talking. We're here to say we're not talking about things that came into his knowledge associated with his representation during the divorce. I realize there's an evidentiary standard, and then I realize that there's the cornerstone of what we do, which is the bar rules, the state bar rule of 1.6. We violate that, and the whole thing comes tumbling down. We're not saying that you can't ask about, did Mr. Wade enjoy a beer at a ball game? That wasn't the question. The question was specifically relating to some impropriety that they are trying to dig into. That is privileged information.
And more importantly, Mr. Bradley has said twice now that he has no independent knowledge as it relates to what she's referencing. He has said it 2 times. So there's not a good faith basis for her to continue to probe into this area, because he said he has no independent knowledge outside of the attorney-client privilege.
All right, Ms. Merchant, last word.
yes, Judge. Judge, Mr. Bradley, if ordered, he's here by subpoena. If ordered to testify, it's not a issue with the bar. My question was not about attorney-client privilege. I'm being very careful not to ask anything that Mr. Wade asked in furtherance, but I've been informed that Robin Yerdy is on the Zoom. And so if we want to start back on our original plan, we can call Miss Yerdy and have her testify, and then put Mr. Wade up, and we can go through the privilege issue with him. And then we won't have to have all these objections, or else I'm happy to continue questioning Mr. Bradley.
All right, so Ms. Merchant, you're saying that your understanding of the evidence that you plan to present that these issues are affected by Ms. Yurdy in terms of the scope of the privilege and the relationship?
No, I think, no, thank you for letting me clarify that. I think that Ms. Yurdy is going to give me enough to get Mr. Wade on the stand. Once I get Mr. Wade on the stand, because they filed a motion to quash, and you said I had to present something before I could put Mr. Wade on the stand. So once I present Ms. Yurdy, I can put Mr. Wade up on the stand, and then I can put him up before I call Mr. Bradley. And then I may not even have to call Mr. Bradley at that point.
All right.
Judge,
Sorry, who's
I'm on
speaking?
Zoom, Your Honor. Attorney Durante Partridge, Judge, on behalf of Ms. Yardy. Your Honor, when we were here for the motion to quash earlier this week, it's my understanding, as represented by defense counsel, that Mr. Bradley's testimony is, so to speak, the bridge that was built to involve my client, Ms. Yardy, into this matter altogether. Now it seems as though that is being usurped, and now she is being the quote unquote foundation for defense counsel's presentation this morning. So we do object to that, Judge, and would renew our motion to quash the subpoena, because this is completely contradictory to what we had via the hearing earlier this week, Your Honor.
Judge, may I
It's okay,
respond?
Ms. Merchant.
Okay.
Mr. Partridge, as I recall, that did not apply to your client as much. The original motion to quash that you filed said she had absolutely no knowledge about anything. What Ms. Merchant proffered, and what I didn't hear you saying was not the case, is that at some point Ms. Yurdy lived in a residence and shared a residence with Ms. Willis and potentially Mr. Wade at some point. So I think she's directly involved in the center of this. I don't think that really needs much in the way of foundation.
And Judge, I apologize, Your Honor, to talk over the court. That information, however, Your Honor, is my understanding, came from Mr. Bradley, and that information was incorrect, as I informed the court earlier this week as well. There was never any time that Ms. Yardy and Ms. Willis lived together. There was a sublet of a condo that Ms. Willis resided in that had absolutely nothing to do with that of Ms. Yardy, outside of Ms. Yardy subletting it to Ms. Willis. Ms. Yardy actually moved into a different residence. Per our conversation with Ms. Merchant yesterday, that is exactly what it is. So there was no overlapping or any time that they stayed together, nor does Ms. Yardy have any information as it relates to Mr. Wade staying at that condo as well with that of Ms. Willis. So again, Judge, I'm renewing.
Okay, no, we don't need to hear it again. Ms. Merchant.
Judge, luckily, I don't have to tell the state or them everything that I plan on introducing a witness for in response to their motion to quash. She has a lot of personal knowledge. And when we had a motion to quash, I had to get over a good faith basis, and I presented that to the court. I did not spend 4 hours going through everything that this woman's going to testify to. She has personal knowledge.
Is she actually here?
I think she's on Zoom. It's what I understand, Mr. Partridge.
Mr.
put her on
Partridge, is
Zoom.
your client with us?
She's on the Zoom platform, Your Honor, since I'm in Richmond County via my conflict, but she is on the Zoom platform at this time, Your Honor, in the waiting room. I believe she may have been admitted. I see a Robin on my screen. I'm assuming that is my client. Ms.
All right,
Yardy.
and Ms. Merchant, you want to examine her by Zoom?
That's fine.
All right,
We will waive
Mr.
any
Abadi.
Sixth Amendment objections to
Sure.
it. That's fine.
My only objection was the representation at Monday's hearing was the good faith basis was based on what she learned from Terrence Bradley. And we know that is false. It's not true. So there is no good faith basis, and we would renew our objection and to quash the subpoena.
That was not in regards to Ms. Yurdy.
It
Judge.
certainly was. It was at like the 20-minute mark in the hearing.
Judge, she has personal knowledge of this relationship.
It's not what was represented on Monday. Personal knowledge came from Mr. Bradley. She has no good faith basis to explore this fishing expedition as it relates to Ms. Yurdy. This is a blatant
All right, Mr. Abadi. Ms. Merchant, I do believe that when we went through the motion to quash, you grouped them into two categories, and each one of them we said that they were going to be impeached by Mr. Bradley.
We took Ms. Yurdy outside of Fulton County, Judge. So we talked about Fulton County differently than Ms. Yurdy. You took Ms. Yurdy out separately. She was different than Fulton County because there wasn't other issues. And again, so we're arguing a motion to quash. I responded to their argument on the motion to quash. Did I tell them that she's going to testify that she's known Miss Willis for years and that her middle name is Latrice? No, I didn't tell them everything she's going to testify to. I don't like, if you wanted me to, I could have, but that has nothing to do. There is a witness that contradicts what they have said in court. And they're doing everything they can to keep her off the stand and keep the truth away from this court. They filed a motion to quash. I showed a good faith basis. If my good faith basis is Mr. Bradley or Miss Yeardy or texts I've seen, it's still a good faith basis. There's no law that says I have to tell them every single good faith basis I have ahead of time. If we did, we would never have trials.
All right, Ms. Merchant, appreciate the argument of counsel. I think the standard on a motion to quash and a subpoena is not one where we're required to completely flesh out and litigate every reason a witness may be relevant. And so we'll take these one at a time with Ms. Yeardy. I'll deny the motion to quash. And if your election and to proceed in your presentation of the evidence is to call her, then that's what we'll do.
Thank you, Judge. So Mr. Bradley, you may be excused for now. Thank you, but subject to recall. We will call Ms. Yeardy. Would you like me to swear her, Judge, or how do you want it?
I think we need to make sure, there we go. Deputy Scott, if we could swear in the witness. Ms. Yeardy, can you hear us?
Yes, I can.
All right.
Raise your right hand, ma'am. You swear affirm to the testimony you should give a court will be the truth, whether the truth will help you.
Yes.
Would you please state and spell your full name for the court?
Robin Latrice Yeardy.
Thank you, Ms. Yeardy. Thank you for being here. Can you tell the judge when you first met Miss Willis?
In college.
Okay.
So 19, probably 90 or 91.
And have you been friends since 1990 or 91?
Yes.
Okay. When was the last time you spoke with Miss Willis?
March of 2022.
Okay. From 1991-ish till 2022, were you what you would consider good friends with Miss Willis?
Yes.
And did you all share personal information regularly?
Yes.
And did you even come and work with her at the DA's office?
Yes.
And when she needed a place to stay, did you let her stay at your apartment?
Yes.
It was a condo, right?
Condo, yes.
Okay. Do you remember approximately when she moved into your condo?
It was April of 2021.
Okay, great. And you know that Miss Willis and Miss Wade met at a conference in October of 2019?
I'm going to object to that, Your Honor, without a foundation for how this witness would know that. If Ms. Merchant can establish she has personal information of that, then certainly that's something the witness can testify to. But if it's she heard
Understood,
it from
Ms. Cross. All right, Ms. Merchant, if you could lay the foundation.
Do you have information that Miss Willis and Mr. Wade met in October of 2019?
I'm going to renew my objection, Your Honor. Information is not sourced to personal information. If the question can be rephrased, then that may address my concern.
So Judge, I just want to make sure that I understand. So they've objected to me calling Willis and Wade.
It's just a matter of foundation. If you can just rephrase.
Do you have knowledge of when Willis and Wade met?
I'm going to object again. Personal knowledge.
Overruled.
Thank you. Do you have personal knowledge of when Willis and Wade met?
Yes. She told me that they met at a conference. I don't know what.
Okay.
I'm going to renew my objection, Your Honor. Clearly, this is not firsthand information from this witness. It's hearsay that was.
She said she told me.
Yes, it's statement against interest, Judge. If Miss
Well,
Willis,
just pause.
I'm sorry.
Okay, Ms.
Yes.
Cross.
The representation of the witness, the testimony of the witness was that Ms. Willis, District Attorney Willis, had a conversation with her. There is no statement against interest. District Attorney Willis is not a party opponent in this case. The information that the witnesses testified to came from Ms. Willis, and we have a hearsay objection to that.
Why wouldn't she be considered a party opponent in this context?
He's a representative of the state, Your Honor. This isn't private litigation or civil litigation. Obviously, the court's aware this is, Ms. Willis is not on trial. Ms. Willis is not a party to the litigation outside her obligation to pursue criminal charges for the state.
Ms. Merchant, I guess it's evolved into a hearsay objection.
Yes, Judge. And we plan on calling Ms. Willis to the stand. She's under subpoena, so hearsay will be cured. If there is a hearsay objection as far as that issue. But we do still think that it's a statement against interest. Ms. Willis has filed a document that states that they met at this municipal court conference. So
Your Honor, I think maybe I can streamline a little bit. State will stipulate that District Attorney Willis and Mr. Wade met in October 2019 at the judicial conference that we've been talking about. There's no reason to get it secondhand from this witness. That's true.
All right, you accept the stipulation, Ms. Merchant?
yes.
All right.
Am I permitted then to ask questions about that since it's now not hearsay?
If it's just to a stipulation, if it's just to that basic fact, I don't think we need a question, but if there's a follow-up that you
Okay.
think is admissible, go for it.
Ms. Yurdi, you have personal knowledge that Ms. Willis and Mr. Wade began their romantic relationship soon after this time that they met at the municipal court.
I'm going to object to that question. That certainly is a leading question. No foundation has been laid for how this witness would have personal knowledge of that. And until that's happened, the state objects.
Judge,
I think you can do a yes or no and then follow up with how she knows it.
thank you. Do you know if Ms. Willis and Mr. Wade started dating in October of 2019?
I don't know if it was October of 2019.
Could it possibly be November of 2019?
Could possibly.
Okay. And when we spoke, you said it was shortly after the municipal court conference, though, correct?
Yes,
Okay. So you know that their relationship, their personal relationship began shortly after this municipal court conference.
yes,
And when I say personal, romantic. I just want to make sure we don't get in an argument over what personal and romantic is later. When I ask you personal, do you take that to mean romantic?
yes,
And do you understand it that their relationship began in 2019 and continued until the last time you spoke with her?
yes,
And you were essentially her best friend during this time, right?
not best friend, good
Okay.
friend.
Good friend. Okay. Close friend. And so would you frequently socialize with her?
Yes,
And you saw her at work every day?
yes,
So you had a chance to see them interact together on a personal level.
yes,
And so from everything that you saw, heard, witnessed, it's your understanding that they were in a romantic relationship beginning in 2019.
yes,
And when you left the DA, I'm sorry, let me ask you. You said that Ms. Willis came to live with you in April of 2021. I'm sorry, April 1st, 2020 or 2021?
she didn't live with me. I never lived with her.
Okay, I'm sorry. She took over your lease in April 1st, 2020, correct?
No, 2021.
Okay, I had it both ways, so I'm glad you clarified. So when she took over your lease in April 1st, 2021, it's your understanding she moved out of the house that she was sharing with her father and started staying at the condo.
Yes,
And is it your understanding that that's because she needed to have her own space
yes,
away from her father?
yes,
When you left the DA's office, was it, were you fired?
no, I resigned.
You resigned, okay. Just one moment, John. Can you tell us why you resigned the DA's office?
The number of things that was happening.
A number of things that were happening. Is that what you said, ma'am?
Yes.
Okay. What was happening that caused you to resign?
It was a spiral of things. So, I guess the last straw is I was put in a department that I knew had no knowledge about. Something happened, and I didn't like it. They didn't like it, and that was it.
Okay. Did you have any falling outs with Miss Willis?
Well, we never spoke after that.
You never spoke after that. Okay. And so you're, without going into all the painstaking details, there is no doubt in your mind that from 2019 until 2022, Miss Willis and Mr. Wade were in a romantic relationship.
What's the question?
You have no doubt that their romantic relationship was in effect from 2019 until the last time you spoke with her.
No doubt.
Okay. And that's based on your personal observations and speaking with them and seeing them together and things like that.
Yes.
Okay. No other questions. Thank you. The other folks may have some questions for you, Mr. Yardie.
Stay down.
Want me to go to the
If it's more than a couple questions, then sure, but if not,
It's only a couple questions.
Okay.
I think, can the court reporter hear me okay?
Yeah.
Ma'am, let me be very specific. Did you talk with Miss Willis about her romantic relationship with Mr. Wade?
Yes.
Did Miss Willis tell you on more than one occasion that she was engaged in a romantic relationship with Mr. Wade prior to you leaving the district attorney's office?
Did she tell me or did I observe?
I'm staying right now with the tell me.
Yes.
Did she tell you that in the year of 2020?
Yes.
In the year of 2021?
Yes.
Are you certain that Miss Willis told you about the romantic relationship with Mr. Wade prior to November 1st of 2021?
Yes.
Now, did you also have observations of Mr. Wade and Miss Willis together prior to November 1st of 2021?
Yes.
And are those observations, were those in a social setting?
Yes.
And did you observe them do things that are, common among people having a romantic relationship?
Yes.
Such as, can you give us an example?
Hugging, kissing, just affection.
All before November 1st of 2021, correct?
Yes.
That's all I have.
Mr. Stocks,
Ma'am, did I understand you to say that there was a period of time when you and Miss Willis lived together?
No.
No further questions.
Mr. Durham,
No, nothing from me, Your Honor.
Mr. McDougald,
Nothing, Your Honor.
Mr. Rice.
Morning, Ms. Yardie. Were you aware in 2021 of any trips, social trips that Miss Willis and Mr. Wade took together?
No.
Are you aware of any social trips that Miss Willis and Mr. Wade took together in 2022?
No.
And are you aware of them in 2020 or 2021 spending the evening together overnight?
No.
No further questions.
Mr. Gillen,
No question, Your Honor.
Mr. McCullough, and Mr. Cromwell.
No questions, Your Honor.
Ms. Cross.
I do have some questions. Thank you, Your Honor. Ms. Yardie, we haven't met before. Is that correct?
Correct.
You're able to see and hear me okay?
Yes.
All right. I want to start with a couple things. Now, I think you've made it clear that you never lived, and we'll call it the South Fulton address, the South Fulton condo that you were leasing. You never lived at that address with the District Attorney Willis, correct?
Correct.
And never at any time?
Never.
All right. You never observed or have any information about District Attorney Wade and District Attorney Willis and Nathan Wade living together, correct?
Correct.
You don't have any information about that?
No, I don't.
Anybody said that that information was sourced to you, then that's incorrect.
That's incorrect.
Did District Attorney Willis pay rent at that establishment, at that condo while she lived there and you were living elsewhere?
Yes,
Who paid the rent?
she did.
Nathan Wade ever pay the rent?
No,
And you never told anyone otherwise?
no,
I didn't hear your answer there, Ms. Yodi. Did you ever tell anyone otherwise?
no.
All right. So let's talk for a second about your time at the district attorney's office. You were disciplined several times in the district attorney's office during your employment there, correct?
No,
You weren't written up ever for poor performance, Ms. Yurdy.
once, not several.
One time you were written up for poor performance. Were you counseled several times about your performance in the district attorney's office that was subpar?
No,
Did the district attorney tell you that your performance was insufficient and that you were going to be fired?
no,
That never happened.
no. Maybe when we went at the end. What's the question?
The question, Ms. Yurdy, was, did the district attorney ever counsel you on your poor performance in the district attorney's office prior and inform you that you were going to be fired?
I don't really know how to answer that.
I'm looking for the truth.
I don't really know how to answer that. I mean, a situation happened that wasn't my fault, and I either was going to resign or be let go. So
You understood that that was the situation. You could resign or you could be let go.
correct, yes,
You were not welcome to stay.
no,
And the conversation where you were informed that you could resign or you could be fired, that conversation was not the first conversation you had with the district attorney about your poor performance in the office, correct?
well, it was kind of a spiral, but no.
Yeah, it was. Whatever the situation was.
Excuse me.
Questions are fine.
Understood, Mr. Sano. Ms. Cross.
Ms. Yurdy, the circumstances of your leaving the district attorney's office ended your friendship with the district attorney Willis, correct?
Yes,
Y'all haven't spoken since.
no,
All right, I want to talk about the representations that you made here this morning, Ms. Yurdy, about any relationship between District Attorney Willis and Mr. Wade. I want you to tell me what was the first time let me ask it this way. You said that District Attorney Willis personally informed you of a romantic relationship. Is that what you testified to?
yes.
And when did that conversation that you purport to have, to recall, when did that happen?
I mean, I don't have a month or a day, but
Where were you?
just talking in general.
Your Honor, we'd like to keep this witness under subpoena, but that's all the questions I have right now.
All right, thank you, Ms. Cross.
Redirect, I'm sorry.
All right, on those points only.
Yes, just those points.
The state asked you a lot about when you were let go, when you resigned. Did something happen as far as purchasing that you didn't feel comfortable with, purchasing things through the county from Ms. Willis that caused you to not be comfortable working there anymore?
No,
And I didn't tell you how to testify here today, though, right?
right,
And everything you've testified to is from your personal knowledge?
yes,
Okay. And you've told the truth here today?
yes,
Judge, I believe she's only under my subpoena and I'm fine releasing her from that subpoena.
Not yet.
Oh, I'm sorry.
By show of hands from other counsel, starting with Mr. Sado.
Your Honor, I believe the door has been opened now to ask this particular witness about statements that Ms. Willis made to her. She brought it up on cross-examination on a couple of occasions. Did Ms. Willis say this or inform you of that? So I'd like to now ask her questions directly about what Ms. Willis told her about her romantic relationship.
I think we'll take those one at a time, question by question, and we can address those to see. I don't know about a complete opening of the door. We'll see where we go.
First time that you spoke to Ms. Willis about her relationship, romantic relationship with Mr. Wade, do you happen to remember what Ms. Willis said? In essence, not word for word, but in essence, what she said.
No,
Do you remember the first time she told you, in whatever words were used, that there was a romantic relationship?
no,
Is this the kind of conversation that you had with your best friend, ongoing over a period of time in which it was common knowledge to you that there was an ongoing relationship between Ms. Willis and Mr. Wade?
what's the question?
I'll ask it again. Is the nature of your then relationship with Ms. Willis such that you were having these ongoing conversations, that is, best friend type conversations about her relationship with Mr. Wade?
I don't remember.
Without getting any further in too much detail, is there any doubt at all that Mr. Wade and Ms. Willis had a romantic relationship, as was told to you, prior to November of 2020?
She was already asked that question by Ms. Merchant.
I just didn't know whether that needed to be.
She said no doubt. All right. Any other defense counsel by show of hands? Seeing none. Last recross from Ms. Cross. Anything else?
Not this time, Your Honor, but we've asked the witness remain under subpoena and subject to recall.
Judge, she's under my subpoena and I'm releasing her from my subpoena. So if they want to subpoena her, they're welcome to do that.
Ms. Cross.
I would prefer that the court keep her under subpoena. I think,
Sure.
Given the representation of Ms. Marchant, given how she intends to proceed today, that this witness may need to be recalled.
All right. Understood. In the interest and knowing that we may have to bring witnesses back and forth, I think it's in the interest of effective presentation of the evidence here. Ms. Yurdi, you are still going to remain under the auspices of your subpoena. And so please stay in touch with your attorney. We may need you to rejoin us on Zoom at some point today or tomorrow. Understood?
Okay,
All right. Don't discuss your testimony with any other potential witnesses. All right.
all right.
All right. You can log off.
And Judge, I'd ask, just can Mr. Partridge stay on for just one moment?
For what reason?
The state had made some allegations that I misrepresented some things to the court, and I'd just like the opportunity to clear that up, that Mr. Partridge is the one that told me that they lived together for a month. They've called me everything but a liar today, and so I just think that it's appropriate for everyone to know where that information came from.
All right, Ms. Merchant, I think you've made your position clear. That's I don't think we need to get sidetracked on that. All right, Ms. Merchant, you can call your next witness.
Judge, may I be excused as well, please?
All right, take care, Mr. Partridge.
You call Mr. Wade.
All right, Ms. Cross.
Your Honor, the motion to quash Mr. Wade's subpoenas was held in abeyance, waiting for the representation. I believe that the good faith basis that Ms. Merchant represented on Monday, I think that that's clearly not accurate. Understand the testimony that's now in the record. Mr. Wade is available, but we maintain that at this time that the motion to quash probably should be granted, but understand the court's ruling.
Well, Ms. Cross, I'll say yes. On Monday, it did seem like the focus was that Mr. Bradley would be the hook that makes every witness potentially relevant, and we really haven't been able to explore that on the privilege issues that we'll likely have to tackle again later. But for now, the evidence in front of the court at the moment is that we have a witness who has said this relationship may have predated the affidavit that Mr. Wade filed. I don't see a way around the relevance of his testimony. And so I'll deny the state's motion to quash the subpoena of Mr. Wade. Ms. Merchant.
Mr. Wade can stand.
Okay, well, it's quiet. Hi, everybody. And I've got to say, CC Ryder, pardon me, Judge, while I go find another witness at the local bar. That's hysterical.
I do.
This is ridiculous, but okay.
My name's Nathan Wade,
Oh, here he is.
NATHANWADE.
Good morning, Mr. Wade.
Good morning.
Prior to filing this motion to disqualify, you and I were friends, correct?
Yes,
And in fact, I supported you when you ran for judge in 2016.
you did.
I wore your shirts. My kids wore your shirts. we
Ms.
carried
Merchant,
signs.
your personal opinions have no relevance.
Okay.
And
I-
I mean that in the best way.
That's
All right.
completely fine. I
Let's
will
get to
move
the
on.
point.
Thank you. No. Totally fine. Thank you. You filed for divorce from your wife on November 2nd, 2021.
Yes, ma'am.
And in that divorce proceeding, did you file answers, things such as interrogatories?
I did.
Okay. And so interrogatories are where you're responding to things that basically answers that the other side is asking.
Yes, ma'am.
And I've got your complaint for divorce. I'm just going to mark it for the record as it is Defendant's Exhibit 2. The first interrogatories that you answered, those were December 27th, 2021. Is that right?
Thereabout. Yes, ma'am.
Okay. And in those, you were asked different things, but those are sworn. You actually swear to those. You verify them, right?
Yes, ma'am.
Okay. And so that verification is where you're swearing under oath that everything in it is true.
Yes, ma'am.
And let's see, you were asked if you had any documents which relate to the purchase of gifts by you to any person other than the defendant with whom you have or had a relationship, romantic relationship from the date of your marriage, correct?
Yes, ma'am.
Okay. And you responded under oath that you didn't have any documents to that.
That's correct.
You again responded to an interrogatory. You updated those responses on May 30th, 2023.
Yes, ma'am.
Okay. And you actually sent those directly to opposing counsel in the divorce?
Yes, ma'am. I think so.
But in that one, you answered none again to that question, correct?
Yes, ma'am.
So May 30th, 2023, you said that you didn't have any documents showing any purchase of anything with someone that you had a romantic relationship with.
I believe the interrogatory was gifts.
Okay.
Not anything, gifts.
And I have it if you want to take a look. I'm going to mark, okay, so just for the record, I've got your complaint for divorce marked as number 2. I've got the verification and the interrogatories from 2021. I'm going to mark those as 3. And then your May 30th, 2023, I'm going to mark as 4. Judge, may I approach the witness?
You may.
Thank you. That is what I marked as 4. This is what I marked as 3. Okay, thank you, Judge. All right, if you take a look at what I marked as 2, 3, and 4. Just see if you recognize those.
I do.
And are those, that's your divorce complaint? And then your 2021 interrogatory and your 2023 interrogatory, correct?
Yes, ma'am.
Okay, are they a fair and accurate representation of what is filed in that case?
Yes, ma'am.
I'd move to admit those into evidence, Judge.
And this is 2, 3, and 4?
It's 2, 3, and 4, yes.
All right. Any objection from the state?
The divorce.
No objection to 3 and 4, and subject to Ms. Merchant's representation that 2 is a filing of divorce. I just don't, the divorce complaint, I don't have that in front of me, but subject to that representation, no objection.
All right. And by show of hands, any objection from other defense counsel? Seeing none, defendants 2, 3, and 4. This should be Romans. Well, we'll just call them 2, 3, and 4 admitted without objection.
So that interrogatory that you filed in 2023, that's the one where you said no, that you didn't have any documents relating to the purchase of gifts, that you had a romantic relationship with someone, right?
Which interrogatory are we talking
Number
about?
4, 2023.
Which number in the interrogatory?
Number 4.
So which number interrogatory are you referring to?
It's defendant's exhibit number 4.
I have defendant's exhibit 4 here.
Uh-huh.
Which number interrogatory are we referring to?
Oh, which number out of the questions?
Yes, ma'am.
Hold on. It is number 20, 24, 25, 26, basically, all of those.
Does it have a number 24? Can you point me to it? No.
Oh, which was you? Oh, this one. Oh, it's supposed to be, sorry. It's supposed to be number 24. I guess they're all numbered 1, so number 1 again, and then the third number 1.
Perhaps you could find the page number or something. So
He
the
didn't
witness
put page
knows.
numbers on. He didn't put any on, we filed it at all. I don't know how to tell you what number 1, because when you responded, you put number 1 on all of them.
You can
So
just point to it.
this one. This one, I'm talking about this number 1 where it's tabbed. There's 2 number 1s that are tabbed,
Okay.
and there's no page number, but it is the second page.
All right.
They're asking if you have any receipts for restaurants, hotels, bars, things like that.
The first number 1,
I believe it's the second number 1.
the second number 1. Okay.
So it asks you if you have any receipts for things like restaurants, bars, hotels, things like that, where you accompanied a member of the other sex romantic partner, correct?
It says identify any and all occasions.
Okay.
Which-
And so go through it with you. It says to identify any and all occasions where you entertained a member of the other sex, okay, who's not related to blood,
Mhm.
and including dining, drinking, restaurants, bars, pubs, hotels, all of that. Okay. And what was your answer to that?
None.
None. Okay. So May 30th, 2023, you prepared this document,
I did.
submitted it,
I did.
and it says none as far as entertaining a member of the opposite sex.
It does.
Okay. No hotels, no bars, no restaurants.
Correct.
Okay. You again updated that. Let's see, you updated it on December 22nd, 2023. And I'm going to mark that as defendant's number 5, and I have copies. Is that correct?
Yes, ma'am.
Okay. And then you updated it once again on January 26th, 2024, correct?
Yes, ma'am.
Okay, there's that one. May I approach the witness again, Judge?
Is that what you're marking as defense exhibit 6?
Yes, Judge, I'm marking number 6 is the January 26th, 2024 interrogatory, and then that one. And then number 5 is the December 22nd, 2023 interrogatory response.
All right. Are you tendering those at this time?
Yes, I am.
All right. Any objection from any counsel to defense exhibit 5 and 6?
Yes, Judge. No objection.
Thank you, Ms. Cross. Seeing none others.
Luckily, I have a ton of those for you. So now that you have those, let's just talk about those for a minute. Those were verified, so sworn under oath.
Mm-hmm.
Okay. And one of them was December 22nd, and then of this last year, so last December, and then one was just recently submitted in January, right?
Mm-hmm.
Okay.
Yes.
In May 10th, 2023, Judge Thompson heard a motion to compel in your divorce case as well, correct?
Yes.
And you were actually held in willful contempt.
Yeah, I'm going to object to the relevance of.
Ms. Merchant.
His credibility is relevant, Judge, and if he was held in willful contempt for failing to provide answers and documents, I think that's relevant to this court.
How is that a prior false act or crime of conviction or anything else allowed for impeachment under the rules of evidence?
I'm not offering it as a prior bad act or something like that. I'm offering it towards his credibility, Judge, which you get to determine. If he's made misrepresentations in these pleadings, you're here to determine whether or not he's telling the truth or not. So if another court has held him in contempt and that's part of the divorce proceeding, I think it's relevant.
But just contempt generally can be for many different things. Like, but a failure to produce is not necessarily a false act, right?
Right, and he's welcome to explain that.
He may not have to. Ms. Cross.
I object to the relevance of that. That's clearly not a proper impeachment. We're going pretty far afield into divorce matters that don't have any direct relevance to anything that's pending before the court. I object to the relevance of that and we further.
All right, not saying that being a proper grounds for impeachment, it's sustained.
Okay, let's talk about this December 22nd, 2023 verification. I tabbed it for you. Again, they asked you if you had any documentations showing proof of this relationship, proof of any relationship, correct?
I'm going to object to the phrasing of that question. I don't believe that's an accurate read of the interrogatory.
All right, let's be precise, Ms. Merchant.
And you please read it. I want to make sure I'm accurate. Please read it.
Which number?
This one actually has a number. I tabbed it for you, so you should be able to open right to the page. It's number 22. The question specifically is if you have any tangible evidence of any nature in your possession or control or any other person or entity which relates to any manner of your activities to any person with whom you've had a sexual relationship during your marriage. Tangible evidence is notes, cards, letters, photos, films, recordings, documents, tapes, video recordings, receipts, invoices, and other tangible evidence.
Yes.
Okay. And you answered that you did not have any documents to that effect, correct?
Correct.
And that was on December 22nd, 2023?
Yes, ma'am.
You updated those responses again after the motion to disqualify was filed, though, correct?
When was the motion filed?
January 8th, 2024, when I filed the motion to disqualify you and alleged that you had a romantic relationship with Miss Willis.
Yes, ma'am.
After that, you updated these responses, correct?
Yes, ma'am.
And so your new responses, you now changed your answer from that you didn't have any of this to you're asserting the privilege under 24-5-505, correct?
Yes, ma'am.
Okay. And both of these are under oath.
Yes, ma'am.
You also updated your response to the question about spending time with someone other than your spouse for dinner, drinks, things at restaurants, bars, hotels, or the other person's home, correct?
Yes, ma'am.
So in December of 2023, you said no to all that. And then in January, after I filed my motion, you said privilege to all that, Fifth Amendment privilege.
Yes, ma'am.
Okay. And just to be clear, was it?
Sorry, I'm going to object the characterization of Fifth Amendment privilege. I think it was a statutory privilege and that's
That's why I was
quite
just-
different.
That's what I was just about to ask him. So that privilege covers infamy or Fifth Amendment privilege, correct?
So it was a privacy privilege is what I updated my response to do. Once
Okay.
you filed your motion to intervene in my divorce action, I then figured that you were in talks with my former wife's divorce lawyer.
Okay.
And because of that, I asserted a privacy privilege because I didn't want the proceedings of my divorce to bleed over into the proceedings in this case, which is the case that obviously you're involved in.
So your answers in December of 2023 that you didn't have any documents about any travel that you took with Miss Willis, that wasn't true though, correct?
They didn't ask me about any documents regarding Miss Willis.
A romantic partner. They asked you for documents regarding a romantic partner. So I'm sorry, I inserted Miss Willis's name. Let me rephrase the question. They asked you for documents about travel with a romantic partner in December 2023. And you under oath said you did not have any of those, correct?
I did not.
Okay.
And they asked me about gifts.
Right.
I've never purchased a gift for Miss Willis.
And they asked you about receipts for dinner, receipts for drinks, hotels, bars, and restaurants. And you said you did not have any of those.
I did not and do not have any receipts for any of those things.
Okay. And part of the civil discovery, they say that even if you don't have it in your pocket, if it's within your purview, you got to get it and give it to them, correct?
Your Honor, I'm going to object again to the relevance of the questions about the scope of civil discovery. I think she's asked him about statements he made in pleadings. The answers are already in the record, and
All right, to the extent you're trying to establish a prior mistruth, Ms. Merchant, I'll allow you to ask a few more follow-ups, but if it's not there, we have to move on.
Thank you. So in 2023, December, you said you didn't have any receipts,
I do not have any receipts. I did not have any receipts.
but you did travel with Miss Willis in 2023, correct?
I did.
And you traveled with her in 2022, correct?
I did.
And you traveled with her in 2021, correct?
No.
So you only traveled with her in 2022 and 2023.
2022 and 2023 is what I recall.
That's what you recall?
Yes.
Okay. So you just don't remember if you traveled with her in 2021?
2022 and 2023 is what I recall.
Is what you recall. My question is, did you travel with her in 2021?
I'm not recalling any travel in 2021.
So it's not yes or no, you just don't remember?
I'm not recalling any travel in 2021.
So you did not travel with her in 2021?
Your Honor.
No, this has been covered. Let's keep going.
Thank you. Let's see, you filed an affidavit in this case, correct?
I did.
Okay, and I marked that already. I gave it to the state as number 1. So that's exhibit number 1. May I approach, Judge?
You may.
Thank you. In that affidavit, you swore under oath, correct?
Yes, ma'am.
And in that affidavit, you swore that, well, first of all, do you recognize the affidavit?
I do.
Okay. Did you sign the affidavit under oath?
I did.
And you gave this affidavit specifically to refute the allegations that I had raised.
Yes, ma'am.
Nobody forced you to sign this?
No, ma'am.
You chose to sign it?
I did.
And you signed it on purpose to admit into court
I
to
did.
refute allegations?
I did.
You signed it specifically to prove that you were not in a relationship with Willis prior to November 2021, correct?
Correct.
And you were a lawyer when you signed it?
I was.
And you're still a lawyer today, correct?
I am.
When were you barred?
1999.
Okay. And you believe that your relationship with Miss Willis is subject to attorney-client privilege, correct?
I'm going to object to that, Your Honor. I don't think that's factually correct. I don't think that's a relevant question, and I don't think it's appropriate to question this witness about the scope of his attorney-client privilege. He's got an attorney who can speak for him for that, but questioning the witness, I think, is inappropriate.
All right, so a lot to unpack there. The question is simply that, does he believe there's a relationship that exists in terms of attorney-client privilege between him and Miss Willis? Is that accurate,
Yes,
Ms.
Judge.
Merchant?
It was. I asked
Okay.
if he believed his relationship with Miss Willis is subject to attorney-client privilege.
Okay, I don't see why yes or no would be barred.
Maybe I'm not understanding the question. If the question is, does Mr. Wade and District Attorney Willis have an attorney-client relationship?
It is not.
There's no foundation for that. If the question to the witness is, does his relationship with District Attorney Willis impact his attorney-client relationship with his divorce attorneys? That I don't think is an appropriate question for that witness. First, first, I believe is a proper phrasing. The second, I think there's been a representation that Mr. Wade preserves and doesn't waive anything. And so I think asking him particular questions in order to potentially backdoor a waiver is inappropriate, and that's my objection.
All right, if we're just trying to, again, assess where a privilege does or does not exist, and we're not actually getting into it, I think we can establish those, parameters. But Ms. Merchant, can you rephrase the question based on that concern, and we'll see where we are?
Yes. Do you believe that your relationship with Miss Willis is subject to an attorney-client privilege? Not if you and Miss Willis have one, but do you believe that relationship is subject to one?
I'm going to object to that question as it's phrased. In what context? Any conversation with his attorneys is privileged. That I think is clear. What's not clear to me from that question is Ms. Merchant asking in the context of your communication with your attorneys, is that, or outside that context, is it?
Right. And Ms. Merchant, I think we need to figure out what are we getting at with this? I'm really
I'm
not
just trying to figure out if
understanding.
he thought that their relationship is subject to an attorney-client privilege. I mean, it's been asserted. I think it's going to be asserted, and that was all I was asking.
I mean, the actions themselves wouldn't be at issue. It's more
If someone
communications.
someone saw them, someone had knowledge of it. Is that
Right.
attorney-client privilege? I want to
All right.
know.
Well, I guess I would find his legal opinion on this isn't relevant. We can deal with that as it comes up. So sustained.
In 2022, in this affidavit, you swore that you and Willis developed a personal relationship.
Yes, ma'am.
And you said that didn't develop until 2022, correct?
That's correct.
And that's different from what you said in your pleading in May 2023 in the divorce case, correct?
No, ma'am.
In May 2023, when you were asked if you had if you'd had any affairs, essentially, and you said none.
That's correct.
Okay. So in May, you said you had not, in May 2023, in the divorce case, you said you had not had a personal relationship, an affair, a romantic relationship with anyone.
That's correct.
But you told this court in the affidavit that you did have one that started in 2022. So that would have been ongoing at 2023.
So here, I think there's a distinction, if you'd allow me to explain. The interrogatory asked the question during the course of your marriage.
Or to date. It actually says.
I'm going to request that the witness be permitted to answer.
Mr. Wade.
So my marriage was irretrievably broken in 2015, ma'am, by agreement. My wife and I agreed that once she had the affair in 2015, that we'd get a divorce. We didn't get a divorce immediately because my children were still in school and I refused to allow them to grow up without their father at the time. So we waited. We waited until the youngest graduated and we dropped her off at college and then filed for the divorce. So if you're asking me about the interrogatory as it relates to having the 2022 relationship with District Attorney Willis, I'm going to say, because my marriage was irretrievably broken, I was free to have a relationship.
So the question, though, was if you had had a relationship. And in 2023, you said you did not. And that is different than what you said in this affidavit, correct?
No, ma'am. I said during the course of my marriage. So in
So you believed it
2015,
too.
Let him finish, Ms. Merchant.
so in 2015, my marriage was irretrievably broken. So I did not have a relationship with anyone during the course of my marriage.
And in that interrogatory, they asked you if you had any receipts for travel with someone of the other sex up until the time you were answering. Is that correct?
Yes, ma'am.
And you said that you didn't. You've already testified to that earlier. But in this affidavit, you said you swore that you had travel expenses and shared expenses on travel with Ms. Willis.
Again, during the course of my marriage, I had no relationship or receipts.
I'm not asking about during the course of your marriage.
Your Honor, I'm going to ask the witness be allowed to answer the question.
Yes, continue. I have no problem with him answering.
Okay. As it relates to receipts today, I don't have any receipts, ma'am.
So you don't have any travel receipts available to you for any travel that you did with Ms. Willis?
I don't have any receipts. No, ma'am.
No receipts that, so you used your business credit card for these trips, correct?
I use my business credit card for everything.
Okay, yes, you did. You used it for your kids' tuition.
Yes, ma'am.
Used it for personal travel with Ms. Willis.
Yes, ma'am.
And you have receipts from those business credit cards that you have to file with your taxes, correct?
No, ma'am.
No.
I filed a statement. I turn over the statement, and whatever's there on the statement, the accountant looks at it, and the accountant says, okay, this is personal, goes over here. This is business, goes over here. Here are your taxes.
So you have those statements. We'll call them statements instead of receipts. You have those statements, correct?
I have the statements, yes, ma'am.
But when you answered the interrogatory under oath, you said you did not have anything to show the records of travel with Ms. Willis.
I answered the question. I had no receipts, ma'am.
You had no receipts, but you had statements.
I ordered the statement, yes, ma'am.
You did order the statement.
I did.
Okay. And so we're just talking to semantics between invoice and statements or receipt. I'm sorry.
I'm going to object, Your Honor, to the argumentative tone of the question. I believe it's been asked and answered several times.
All right, sustain.
Let's see. You also in this affidavit said that no funds paid to you for compensation as your role as special counsel was shared with Willis, correct?
That's correct.
And that you never cohabitated with Willis, correct?
That's correct.
By cohabitation, does that mean that you never spent the night with Willis?
I spent the night with her during
Spent the
travel. Yes, ma'am.
Okay. And so I just want to qualify your use of the term cohabitation. That means you didn't live together,
That's correct.
but you did spend the night together.
Yes.
When was the first time you spent the night together?
Your Honor,
That's the subject of his affidavit, Judge.
Right, but it might not be the subject of this hearing. So the question is the nature and extent of the relationship. And so if they just spent the night on a single occasion, I don't think we're going to document in detail every single time that happened.
And I don't intend to do that, Judge, but I think what is relevant is when the relationship started. And that's what you had indicated on.
Well, why don't we start with that question and go from there?
And that's what I asked, when the first time he spent the night with her was. That's what I asked.
That's a different question, isn't it?
$2022.
So you were appointed in November of 2021
Yes, ma'am.
and your relationship started early. What's early? January, February?
Around March.
Around March. But you two met at an October 2019 judicial conference, correct?
Yes, ma'am.
And describe your relationship at that point then.
Which point?
2019.
So I was at a judicial conference to teach a course, if you will, to newer judges. I did that in 2019. As I was exiting the conference, another judge was standing outside who was a friend of mine. I stopped and exchanged pleasantries with her. And standing, talking to her at the time was then Judge Willis. She introduced us at that time. We shook hands, exchanged business cards, and I got into my vehicle and left the conference. So that meeting was probably 3 minutes.
Okay. When was the next time you talked to her?
Didn't talk to her again, probably maybe a month or a month and a half had gone by.
Okay. So you talked to her November, maybe?
Maybe.
On the phone?
On the phone.
Okay. How regularly did you speak with her in 2021 on the phone?
In 2021?
I'm sorry, 2019. I'm so sorry. 2019. How frequently did you speak with her on the phone?
2019, after the meeting, I probably talked to her 2 or 3 times. She would have questions. I was the district rep for the particular district that I sat in. And the judges would, when they would have questions, they sometimes would go to the rep. So she was outside of my district, but she would call me. She felt comfortable calling me to ask me the questions. I don't know if you know the racial makeup of certain benches, but it wasn't very diverse. So she felt comfortable calling me for advice. And she did that. And we had also in common that she was starting a private law practice at the time, and I'd already had mine up and going, and we talked about balancing the demands of the bench with that private practice. So we didn't talk that often, but when she had questions, mostly legal issues that would come up, she would call me.
I just want to make sure, because my question was just how many times, and you said 2 to 3 times, right?
Yeah.
Okay. And in 2022, how frequently did you speak in 2022? This is before you were appointed.
I'm sorry, perhaps Ms. Merchants, your timeline, 2022?
I'm sorry, 2020. 2020. How frequently did you speak in 2020?
2020, it was more frequent than 19, obviously, but
More frequent. Can you tell me approximately a month how often you think you spoke with her on the phone?
Your Honor, I'm going to object to the granular detail. I think Mr. Wade can certainly answer however he wants to, but if we're going to go through every time we spoke on the phone, as opposed to generally characterizing the relationship, it would be more detailed than is necessary.
Judge, I'm not going to go through every time they spoke on the phone. I'm asking for generally how frequently they spoke.
I think at that level, that's fine. Overruled.
About how frequently did you speak in 2020?
per month.
I mean, if it was 2 or 3 times that entire year, you can tell me that. If
Oh, no,
it
no,
was
no.
more than that, then you can quantify it by month.
No. We spoke on the telephone often. I mean, I don't know how many. I couldn't give you a amount of times because you remember COVID happened and the world was shut down. But so we spoke on the phone more than 2019, definitely.
Okay, let's qualify it. Before her election in 2020, how frequently did you speak?
You mean as she was campaigning?
Before the election. Yes, as she was campaigning, before she was elected.
It's 2 different animals.
As she was campaigning before she was elected.
Okay, so during the course of her campaign, we didn't talk as much, obviously, because she was busy. Fulton County is a large jurisdiction to cover. So we didn't talk a whole lot, but she did know that I'd gone through the election process. So when things would come up that she had questions about, she would call me and ask me. So
and just to be fair,
sometimes it would
I'm
be
only
Ms. Merchant.
Judge, actually, he's not asked and answered. And I mean, I don't mind him explaining, but I just wanted to know how many times. I mean, if we talk about every conversation they talked about,
You gotta let him finish his sentence, and then if you need to redirect him or have me direct him, I can. Mr. Wade, you can continue.
Yes, sir. So sometimes it would be like a 3-second call. She would go, during your election, have you ever seen this? And I would say, no, but here's what I would do. And we'd hang up. She had a lot of professionals working for her, but she trusted my judgment. So she called me. And it'd be brief conversation, but she called.
so my question was, how frequently did you speak with her prior to her election?
I
Frequently? Infrequently?
more than 2019, but it wasn't a everyday thing. No.
In 2021, before you were appointed in November, so January to November 2021, the only time I'm talking about, how frequently did you speak with Ms. Willis on the phone?
In 2021, then it became frequent.
Frequent.
Yes,
But you did not work at the DA's office at that point, correct?
I did not.
So the affidavit that you submitted, you showed on it, you submitted one record that showed that Ms. Willis had paid a couple $100s for one flight, correct?
Say again?
The affidavit that you submitted to this court
Mm-hmm.
showed that Ms. Willis had paid for one flight several $100s. Is that correct?
No, ma'am. I think that, are you drawing a distinction for her paying for a flight or for her actually booking a flight? Because those are 2 separate things.
I will re-ask it.
Okay.
The affidavit you filed in this court,
Mhm.
you alleged that Ms. Willis paid for one flight. Paid for one flight, correct?
No, ma'am.
You
No,
did not
ma'am.
allege she paid for one flight.
No, ma'am. What I allege is that our travel was split roughly evenly. So where you see I have booked a flight or I've paid for a flight with my credit card, what you don't see is that she covered her own flight reimbursement to me. The flights that you see here are the flights that she would have booked with her own resources, with her own card.
And there's one flight, correct?
One flight reflecting that she
submitted
actually
one
booked
flight.
Ms. Merchant, let him finish and then you can redirect him.
one flight that she actually booked? Yes. The other flights I booked, she paid for.
So the affidavit, you submitted one flight that she booked and paid for.
Yes, ma'am.
Your Honor,
Thank
I'm going to object to the phrasing of that question. The line in the affidavit is not as Ms. Merchant is representing it. It said examples of the District Attorney Willis purchasing plane tickets for she and I with her personal funds were attached as an exhibit. It certainly did not represent that it was the only example of the District Attorney purchasing flights for Mr. Wade or for compensating other travel.
All right, understand, Ms. Cross. I think that's something you can, it's now on the record, but also something you can take on cross.
Thank you. And just so everybody's clear, all I asked you is your affidavit, you submitted proof of one flight that she paid for and booked. That's all I'm asking. Correct?
With the explanation, yes, ma'am.
All I needed. You said in the affidavit that you roughly shared travel though, correct?
Yes, ma'am.
Okay. So this roughly sharing travel, you're saying she reimbursed you.
She did.
And where did you deposit the money she reimbursed you?
I was cash. She didn't give me any checks.
So she paid you cash for her share of all these vacations.
Mr. Schaefer, you'll step out if you do that again.
Yes, ma'am.
Okay. And so all of the vacations that she took, she paid you cash for.
Yes, ma'am.
And you purchased all of these vacations on your business credit card, correct?
Yes, ma'am.
And you included those in deductions on your taxes, correct?
No, ma'am.
No, you did not.
No, ma'am.
Okay. We'll get to that in just a minute then. Let's see. So the only thing that you have actual documentary proof, not cash, is this one receipt that you attached to the affidavit. Is that correct?
Your Honor, I object to that question. That is a mischaracterization of the assertion that is in the affidavit.
I'm asking.
So then he can deny it. I think he can fend for himself. Ms. Merchant.
Is this the only written proof that you have of a trip she paid for?
That I have?
Yes.
Yes, ma'am.
Okay. So you submitted the one piece of written evidence that you have that she paid for something. Everything else is in cash. Is that accurate?
No.
That's not accurate. Okay. Please tell me, what other receipts do you have then that show that she paid for things?
I don't have them.
Okay. So this is the only receipt that you have to show that she paid for travel.
That I have. Yes, ma'am.
Thank you. In your divorce case, you filed a domestic relations financial affidavit, correct?
Yes, ma'am.
The first one you filed was in January 2022, right?
Thereabout. Yes, ma'am.
And those are under oath?
Yes.
Okay. And you also filed corporate taxes in 2022, correct?
Yeah.
And tell me about your business. Do you have a partnership or are you a solo practitioner?
As it stands today?
Yes.
So today, I have a separate PC. My law partner has his own separate PC.
Okay.
So, but we're under the same umbrella, under the same roof. So we share expenses, we share income, and we split it.
So are you a partnership?
We are a partnership in the sense of we share expenses, we share income.
Are you registered with the state of Georgia as a partnership?
So the WBC firm that included myself, Terrence Bradley, and Christopher Campbell, we were registered with the Secretary of State as a partnership for a short period of time.
That
When
was dissolved, though, right, in 2023?
I'm going to object to the witness answer his question.
Mr. Wade, do you have something else to add there?
I did, when things happened and we excused Mr. Bradley from that partnership, it left Christopher Campbell and myself. So now you have two separate PCs under the same umbrella, sharing expenses and income.
Okay. So let me just narrow down my questions then. Are you registered And have you been registered at any time in the state of Georgia as Wade and Campbell?
Wade, no, ma'am.
You've never been registered as a partnership?
As Wade and Campbell, no,
Wade and
ma'am.
Campbell, yes, thank you.
But as Wade Bradley Campbell, yes, ma'am.
Wade Bradley Campbell was registered on April 1st, 2021, and administratively dissolved on September 8th, 2023, correct?
Yes, ma'am.
Other than that partnership, you have always been registered as law office of Nathan Wade,
Yes, ma'am.
not with Chris Campbell.
Correct.
Thank you. So the affidavit that you filed in your divorce case, the first one in 2022. I think I'm up to number 7. I'm going to just show you, give you a group of exhibits so we don't have to go back and forth. I'm marking the 2022 as 7. I'm marking the 2024 as 8. I'm marking the credit card statements as 9, and your taxes as 10.
I'm gonna,
Copies.
I
I've got
object to taxes, because of the relevance of them at this point. The relevance of this entire business structure doesn't seem clear to me as either impeaching or relevant to the issues at the courts, under the court's consideration. But insofar as we're talking about tax returns and other things like that, certainly that's, should be redacted, and I would object to the relevance of it.
I agree they should be redacted. I don't agree to the relevance, but I haven't tried to tender them yet, Judge. I'm just marking them right now so that everyone can follow.
All right. And what is the eventual relevance that you were getting at here?
Well, I'm going to ask him because one of the things that we have to show in this case is a personal and financial interest. So, and he's talked about how he was reimbursed for these things. And so I have a right to go into the veracity of those statements. So let's see, 7, 8, sorry. 9. And then 10. All right, so right now I'm just going to show you what I've marked. As these exhibits.
Okay, everybody, I've turned this down for a minute. I just wanted to, this is exhausting and stupid, but okay. Basically, while they're working out whatever they're working out, as it says, defendants in the Trump RICO case are trying to get the RICO case thrown out by proving that not only did Willis and Wade have a relationship, but their relationship, Willis financially benefited by hiring her lover, because of course they're trying to humiliate her as if it's 1950. By hiring her lover Wade, and that they both lied about when their relationship started in documents. So CC Ryder says, yo, McAfee, MAGA wants to introduce any and all evidence unrelated to destroy this man now and down the line. Absolutely. Thank you, Denise. So I pulled some questions because, oh gosh, who was it? I'm so sorry. The question was, will Judge McAfee remove Willis from the Trump RICO case? All right. Here's the thing. I keep pulling cards on this kind of question, and I keep getting a little bit frustrated because it looks like this was just a personal relationship, and there's not much here. They won't be able to prove much. But I keep ending in things like the Justice card, the Chariot card, which I believe is and things like this, which I believe is things moving forward. In this question of will Willis be removed from the RICO case, will McAfee remove Willis? I don't have anything like a Tower card or I don't have anything like that. I've got a lot of legal worry, but that could be on the other side. So what Kelly's asking, could this be remedied by Wade recusing himself? Well, no, the MAGA lawyers, they don't want to accept that because they want to say that Wade and Willis lied under oath by lying about when their relationship started. And if they are removed from the RICO case, there's a possibility the whole RICO case goes poof. because the MAGA side is trying to argue that the whole thing was just a money-making operation. So, Kurt Levin says, I got a no. 10 of Wands with 5 of Cups reversed. Okay, thank you. So, yeah, so that's what they're trying to do. Pat Lau says, not being a lawyer, this all seems to me to be a whole lot of nothing. Oh, I understand that. Is Wade, and it isn't Wade who had the affair. In 2015, it was his wife, for what it's worth. CC Ryder says, Fani and Wade need to double down and stay on the case. Do not bow to the pressure. Oh gosh, would they actually bow to the pressure? It would blow up the possibly the biggest cases of their lives. I don't know that they're going to walk away from that. I think you're right. Then again, CC Ryder, you always are. Yeah, they're just trying to humiliate these people, especially because they are people of color. So, of course, Trump, Winston, and Roman, and all of them. Far-right victory, they're trying to go for that. King of Swords and Temperance. So, in the court of public opinion, the MAGA side of this may win some points with certain people, but this is a pretty level-headed judge in the middle, and I've got Temperance at the end, which is everybody slow your roll. That's what I'm getting. But are they going to work? Are there going to be semantics about receipts versus statements versus? These are lawyers. And Nathan Wade and Fani Willis did not get to where they are by suddenly being called as a witness and standing up there and going, that's it, you got me. Yep, absolutely. I completely lied. Yes, you can absolutely prove I just lied to the court. No, I mean, that's not going to happen. This isn't, who's Donald Trump's favorite fictional lawyer? Books are written by Gardner. Perry Mason. This is not Perry Mason. So, yeah. So anyway, that's what we're listening to see if I mean, are they going to try to get Wade disbarred for lying? Yeah. Okay, are they going to get Wade disbarred for lying under oath? They're not letting this go. They're just going to keep pounding on this. I'm not necessarily getting him getting the 3 of Swords. I am absolutely getting the 6 of Cups being he just keeps on keeping on, and they are just beside themselves. How dare we be held accountable for trying to destroy democracy in our country? And this is important because this is also, I would argue, this is also a test of whether people of color, professional people of color in this country, will be treated fairly. CC Writers of CNN and the New York Post online articles say Wade and Willis should step down. Media pressure campaign is out there against them. I doubt it. Are either of them going to step down? Are either of them going to step down? This case is massive. Yes, David Minard. RICO law. Are either of them going to step down? They want to put these jerks in prison. On the right, they're just trying to stir things up. 4 of Cups. They're refusing. They no matter how much evidence they have or don't have, they're just refusing to listen. And there's a legal decision there, but this is all minor arcana. This is a whole lot of weakness. So, anyway, so but this is important. I believe this case, and I'll ask, is this case important? Really, as not only giving Trump and his ilk another loss, but also the rights of the respect of professional people of color. Is this case important in the long run? See, Cherry Bomb says it's just depressing, though. Well, yeah. Yeah, it's important. The star's there. Adding insult to injury, and the right of the people to be there, and the person in red having to walking away. But this is very stressful. But there's a bigger picture here. T. Clever says historical. Okay. CC Ryder says they know what is happening. Both Fani and Nathan Wade. Sorry, I should have taken this banner down while I was talking. Sorry about that. Both Fani and Nathan Wade need to ignore the pressure and hang tough. Don't voluntarily step down, fight back, and prosecute these blankety blanks. I agree 100%. Colonel Evans says, I got these 6 of Swords also, and then Justice. I've read as Justice against Trump, but a different prosecutor. Okay. Elflower One Star says, how many yacht fares did 45 have during his presidency? True. The RICO case go forward with a different prosecutor. Somebody with these 2 off the case and a different prosecutor. I'm getting the cards. It doesn't even matter what the cards say, because the point of the cards is the energy does not. I think there's a problem with the question. McAfee. Okay, judgment. That's McAfee deciding. The judge deciding. This is the right. They're coming up with all of this. Oh, thank you, R.D. Lewis. Thank you. They're coming up with all of these arguments, all of this nonsense. And here's the truth and a suspension. But it could be a suspension of this situation. So as for some clarification, there's Fani Willis. She's the Queen of Swords. Again, the person in red having to walk away, death card, and there's Trump having to face the charges. So I think that what these people who are going after Wade and Willis have not taken into account. CC Ryder, I am sensing McAfee will determine the defense did not meet the burden of proof. Yeah. What was I going to say? Okay, I was going to say something and now it went straight out of my head. So, hang tough, Wade. Hang tough, Willis. Cherry Bomb is asking, what if 45 doesn't make it to court? The prosecutors do, but he doesn't? You're talking about the Bragg case in New York? Eileen Case's Twitter reflecting, the testimony suggests they may have misrepresented timing of the relationship, question mark. But what's the relationship? These are lawyers. That's what I was going to say. These people have completely, they think they're going to go after these two prosecutors, and they honestly underestimated them. Because Trump's a racist, blankety blank, and the people who work, who went into this, who tried to overturn democracy with him are not exactly liberal equality, people fighting for equality. But they underestimated who they're dealing with. So Wade and Willis could say, what's a relationship? We didn't get married. We didn't get engaged. We didn't live together. We spent a couple of nights together. Whatever. Take care, Eileen. So all right, we'll listen, see how they're, the woman is Merchant, and then that is Nathan Wade over there. And that's Judge McAfee. Okay, let's listen in again.
They were.
And so I know you said that you were worried about security and things like that, but that was in her name.
And yes, Kelly, the RICO
when she traveled, she had to use her name.
can
Oh,
carry
so
real
the
chips
plane tickets, yes, ma'am.
for Trump.
Okay.
Yes.
And you paid for those plane tickets and you paid for a hotel.
So again, the card, yes.
You used your credit card, and I'm not asking about after what happened. I'm asking, did you use your credit card to book your flight and hotel to California?
I did.
And there's a lot of Ubers on there as well for California. Did you pay for those Ubers as well?
Yes.
Did
We were in Napa.
And you're saying that Miss Willis, are you saying that Miss Willis paid you back for that?
Yes.
Did she pay for the entire trip, or did she pay for her half of the trip?
The Napa trip,
Mhm.
she paid for the excursions. So the expenses sort of balanced out. I mean, there was never, let me be clear, there was never a time when I would say, hey, I bought dinner. Dinner cost $25. You need to give me $25.
Okay.
If you've ever spent any time with Miss Willis, you understand that she's a very independent, proud woman.
I'd object. We're not.
So she's going to
Overruled, Mr. Wade.
so she's going to insist that she carries her own weight. And it actually was a point of contention between the two of us. She is going to pay her own way.
So let me re-ask the question to make sure that you answer it. A California trip that you paid for, are you saying that she did not pay you back for cash? Instead, she paid for excursions, and you believe that was roughly half?
You know, she gave me some cash, yes.
She
But
gave you
what I'm
some
saying is everything that we did when we got into Napa,
Mhm.
she paid for.
The trip that she booked on her credit card in Miami, did you pay her cash back for your half of that?
No,
So you never paid her
No.
back for the ticket she bought for you?
no. I would say I did pay her back because there were times when I would pay for dinner.
Okay.
She would pay for dinner. It would balance out. But in a relationship, ma'am, you don't, particularly men, we don't go asking back for anything. So you're not keeping a ledger of things that you pay for versus the thing that she's paid for, which is why I said that it was a point of contention because she was very emphatic and adamant about this independent, strong woman thing. So she demanded that she pay her own way.
But she's the district attorney of Fulton County, and she has to file financial disclosures disclosing any gifts with anybody that she does business with in Fulton County, correct?
I don't know.
Okay. Let's talk about Tennessee. You booked a cabin in August 2023 and paid for a cabin in Tennessee. That's when you paid for it. I don't know when the trip was. Can you tell us about that?
August of 2023.
You booked a trip for $1,481.54.
Are you asking me, did I take that trip with Miss Willis, or are you asking me?
First, I was just asking you to acknowledge that that is correct from the records, that you
Oh.
paid for a cabin in Tennessee. Do you recall, and hopefully you can do it from your memory, do you recall paying for a cabin 6 months ago, $1,400.81 in Tennessee.
Where are we now? What page is that?
I'm just asking from your memory. Do you remember paying for a cabin in August?
Your Honor, if he's going to be asked about a particular transaction.
He can answer whether he remembers or not.
I don't.
Mr. Wade, I'm not asking you to go through 1,000 pages of records. I'm asking if you remember paying for a cabin 6 months ago in Tennessee.
No,
You remember booking a cabin?
I booked lots of cabins.
Did you go to a cabin with Miss Willis ever?
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 No,
Never gone to a cabin with Miss Willis?
no,
Have you ever gone to Tennessee with Miss Willis?
yes.
Okay. When was that?
That was around 2022, early 2022.
Early 2022? Okay.
It was a day trip.
Okay. So you didn't spend
We
the night?
would, so it was a day trip.
Okay.
We would drive there, have lunch, drive back. The reason we would do that is because the attention, she couldn't get any peace of mind going locally. So we'd get in my car and drive to someplace off the beaten path and have lunch and drive back.
Is that when you went to Fainting Goat with her? I think it's in Jasper, Georgia.
No, that's in Georgia. I don't recall going to Fainting Goat with her.
So the Tennessee day trips were only Tennessee.
Yes.
Okay. Did you ever do these day trips in Georgia?
I just want to say,
Do we drive anywhere in Georgia?
Yeah, you were talking about day trips
we
going
drove-
out, and I'm talking about outside of the metro area.
hang on,
Day
I just
trips,
want to
we were
say,
just talking about
Teresa
those trips we were
Ford
talking about.
said, I
The
think he
ones
might
that
be
you were-
enjoying
I'm
Donald's
only
answers.
asking
It
about the
seems
ones
to
you were
really
just
annoy
talking
her.
about. Are all of
I
those
think
in
I see a
Tennessee?
little twinkle in his eye when he does that. I noticed
No,
that too.
we
That was,
drove to Alabama before.
I think he's
Okay.
trolling her a little
You
bit.
drove to Alabama?
And
Did you go anywhere in Georgia? North Georgia?
what's your point, lady?
Yeah, I'm going to object. If she wants to direct his attention in some way to a time frame or a location, then I think it might be easier for the
All
witness
right.
to accurately
Ms.
answer.
Merchant, I think if you don't have the specific details yourself,
Mhm.
we need to start getting into specifics or more maybe broadly phrased questions. We can't just be exploring around indefinitely.
Is it fair to say that you've taken so many trips with her, you don't even really remember all the places you've gone?
So many trips.
You're having trouble remembering going if you went to North Georgia or not.
Were you asking me about specific places? And I want to be candid in my responses. So I have to jog my memory because these are places that I have frequented, but not with her. So I want to make certain that if there was ever a time that she accompanied me, that I was candid in that response.
Aruba, October 2022. And I've got business record certificate for these, Judge. Might be a little faster. But did you take a trip with her to Aruba in 2022?
Yes, ma'am. So that Aruba trip there was a package deal there. My mother had recently retired, and I decided to take my mother on a cruise.
Okay.
And the second leg after the cruise concluded, DA Willis and I went to Aruba. So that was all one trip if you will.
Okay, so my question was, did you go with DA Willis to Aruba in 2022?
I did.
Thank you. And you paid for that trip using your business credit card, correct?
I did.
And you paid for a cruise as well, correct?
That's the cruise I was referencing with DA Willis, my mother, and myself.
Okay, and because there's two cruises, so let's just talk about the first one.
Okay.
So the first one was that's the one with your mother.
Yes.
And so you introduced DA Willis to your mother that trip. You all took a cruise together, the three of you.
Yes.
After the cruise was done, you and DA Willis flew to Aruba together, and your mom flew home.
Yes.
And you paid for all of this with your credit card, on your business credit card.
I did.
And are you saying that Miss Willis paid you cash back for that?
She did. Now,
And-
but let me make this distinction though, because the number that you're looking at reflects the 3 people on the cruise ship. There were things that my mother and I did, just the 2 of us, that DA Willis didn't do.
And I'm not attributing that. I did not. My math is not good, but I did not include anything with your mother on those. Can I show?
You wouldn't be able to see it because it's not separated out. It just shows a charge on the account when actually it would have been something with my mother and I.
This seems to be proving
Judge
that
May
Nathan
approached
Wade
with
is a
exhibits 10
gentleman.
and 11. They're both certified business records from, one's from Vacation Express, one's from H2.
I thought 10 was taxes.
I'm sorry, 11 and 12.
And by the way, I just want to throw this in. I use one credit card for my business and personal because I get cash back that I use for Christmas.
And these are business records, Judge. They have the certification, so you can
And it's all
All right. Defense
it's all
11 and
worked out
12. Ms.
on my
Cross.
taxes.
Based on Ms. Merchant's representation that they are true and accurate as to the certification that was provided to her, we have no question.
All right. Again, seeing no other objection there, admitted.
So the trip to Aruba alone for you and DA Willis was $3,835.26, correct? Just Aruba.
I'm looking for the amount.
Exhibit, she's questioning about 11 or 12.
This one is 11.
Yes, ma'am. $3,835.26.
And then the Royal Caribbean for just you and Miss Willis was $1,269.70, correct?
No, ma'am.
Your mother's got a different line item on there. I'm talking about the cruise, the actual cruise cabin.
I think you need to rephrase that as in the form of a question, Ms. Merchant.
Did you pay Royal Caribbean for yours and Miss Willis's cabin $1,269.70?
Where are we? Which page?
We're on the receipts. There's just a few pages of receipts on exhibit number 11.
Okay.
A few pages.
I'm in 11.
Jeez.
Can you direct me to where you are on in exhibit 11?
Oh, you can roll your eyes, lady,
Caribbean?
but it's your question. Unbelievable.
So we've got your flights on the one page. Which I already
Malcolm's
asked you about
Cottage.
for
What does that
Aruba.
got to? What?
And then,
That's not relevant here. I don't think. Anything like that. Hell, thank you.
and just for the
Google
record, I blacked out their dates of birth. And then Royal Caribbean may be on.
I agree, Stacey
Oh,
Ryder.
it's
It's
small.
actually
It's hard to read.
I agree.
Very hard to read. So let me just figure this out. You recall paying around $1,269.70 for a Royal Caribbean cruise for you and Miss Willis. You don't remember that?
That amount seems kind of small. I think
Okay,
it's
so you believe it was higher?
Yeah.
Okay. While you were in Aruba, then you bought a cruise, a Norwegian cruise, right? And that was the New Year's Eve cruise?
while I was in Aruba. No, ma'am.
The credit card documents that were admitted earlier show the purchase date when you were in Aruba, but you don't remember doing that in Aruba?
I didn't purchase a cruise while I was in Aruba. That may be when the cruise company decided to run the invoice, but I didn't purchase a cruise in Aruba, no ma'am.
Around the time you went to Aruba, you purchased a cruise for Norwegian for you and Miss Willis to take for New Year's, correct?
Before I went to Aruba, yes ma'am.
And that was roughly $3,387. The cruise to Aruba. I mean, the cruise to, I'm sorry, the Norwegian cruise.
So that cruise was with my sisters.
Okay.
And the number that you are seeing would reflect my buying dinner for my sisters and their husbands, or
I'm just
me.
talking about the cruise, the amount that was paid for the cruise ahead of time when you
No,
booked the cruise.
these seem like pretty
I'm just talking about
reasonable,
that.
vacation
Okay.
expenses.
That was a little over $3,000.
Yes, ma'am.
Okay. So, and I understand you're saying you paid for other things, but I'm just talking about the cruise amount. And you paid for a Jeep and you paid for dinner while you were there in Bahamas.
Oh, lawyers make a lot of money.
Yes, ma'am.
That's the one that Miss Willis paid for a flight for, correct?
That's one of the flights she paid for. Yes, ma'am.
Actually, a documented paid for, not cash. I'm talking about a non-cash transaction. That's what she paid for.
You mean the one that I provided the receipt for?
Yes.
Yes, ma'am. That's that.
And so she booked that on her credit card and wasn't worried about, I know you said earlier that you were booking everything because she was worried about people knowing where she was traveling. She didn't have any fears booking that one though, correct?
I'm going to object to the phrasing of that question, to speculate as to what was the motivation of the district attorney. If she wants to ask if that was the transaction, they can respond if that was a transaction.
Ms. Merchant, I think you can rephrase the question, but I'll sustain it on the current phrasing.
So she purchased that under her own name, correct?
She did.
Okay. Let's see. So I know we talked a little bit about the seminar where you all met. Isn't it true that you would go to Miss Willis's house in South Fulton County occasionally?
I've never gone to her house in South Fulton County.
You've never gone to her house in South
I've never seen her house. The first time I even heard the address of that house was when one of the individuals in the election fraud case somehow doxed it and it got out. That was the first time I'd even seen that address.
But you would go to the East Point condo, correct?
What East Point condo?
East Point, Hapeville, something like that.
I've never been to East Point with Miss Willis.
You've never gone to a condo in either the East Point or Hapeville area with Miss Willis.
Wait, that's different. I have gone to a condo in Hapeville.
Okay. So Hapeville.
Yes, ma'am.
So you have gone to a condo with Miss Willis in Hapeville.
I have.
Have you spent the night there?
Never.
Never spent the night.
Never.
Is that the condo that was rented by Robin Yurdy?
I believe it was.
And other members of the DA staff were there as well, correct? Sometimes.
I've never been around other members of the DA staff at a condo in Hapeville.
There's never been any security for Miss Willis?
Not around me.
Did you ever ride with Miss Willis with her security detail to and from the house?
No.
You served on Miss Willis's transition team, correct?
Yes.
And you were part of all of her interviews where she interviewed and re-interviewed employees?
I would say probably 98, 99% of them, yes.
Is it fair to say you took an active role in these interviews?
Yes, ma'am.
But prior to this, you'd never worked at a DA's office, right?
Have I ever worked in her DA's office?
At
No,
a
ma'am.
DA's office, any DA's office.
No, ma'am.
Have you ever managed a large law firm or a
Your
large?
Honor, I'm going to object to the relevance of these questions.
Ms. Merchant.
He served on her transition team. And so, I mean, what we're trying to prove is that there's a personal and financial relationship and that it was improper. And so, you know, whether or not he had experience to serve on this transition team, I think is relevant.
Right. I think I already said that we don't need the evidence you're
Okay.
hearing on that point.
I'll
So
move on.
that's sustained.
Terrence Bradley also received a contract for Fulton County, correct? Correct.
You're asking me about Terrence?
I asked if Terrence Bradley also received a contract for Fulton County.
I believe that he did.
And you were partners with him at that time, correct?
I was.
So under what you testified to earlier, you would get a third of that contract as well, correct?
I would have.
And Chris Campbell also had a contract with Fulton County.
I believe he did.
And so under what you've testified to, you would also get a third of that, correct?
I would.
They both had contracts for what are called first appearance, which is where they would appear on behalf of the district attorney to do first appearance hearings, correct?
I believe they did.
Okay. And they also had what's called a taint contract. They both entered into them January 25th, 2021, correct?
Filter, yes, ma'am.
Taint or filter.
Yes, ma'am.
And that was for work in the anti-corruption unit?
Thank you, Patricia.
I don't know that it was anti-corruption. I think that it was civil rights, maybe.
And Judge, the DAs or Fulton County's come and I guess brought a certificate now. So we would move to admit the contracts. I've got those. Under that certificate, I was planning on doing it under the open records officer, but I believe now they've certified it. I haven't looked at everything they've certified though, so.
I'm going to
All right.
ask that the document be looked at and confirmed prior to its surrender.
All right, Ms. Merchant, is there anything else? What other areas were you planning to cover on his direct other than these documents?
I'm planning on introducing all of the contracts and invoices, but I haven't had a chance to look at what Fulton County certified. So I'm planning on introducing those and then not much.
Can we do the not much?
Hmm?
And then we'll do the not much and then we'll get back to the contracts.
Okay, yeah, definitely. Okay, so this taint contract, and we're not admitting these right now, but if I represent to you that they say anti-corruption unit, can you tell us what a taint attorney for an anti-corruption unit would do?
I didn't have a part in those contracts.
They were your partners at the time though, correct?
Oh, absolutely.
Okay. And so you didn't have a part in those contracts, but you got a third of the contract payment.
Oh, absolutely.
Okay. So the taint contracts that Bradley and Campbell, who are your law partners at the time, had for doing taint review, you got a third of those.
Yes, ma'am.
Okay. You signed a confidentiality agreement with the DA's office as well, correct?
I did.
And I think I'm up to Judge 13. Marking that as number 13. No. May I approach, Judge?
You may.
Showing you a copy of what I marked as number 13. If you could take a look at that and tell me if that is the confidentiality agreement that you signed with the district attorney.
It is.
And this basically says you can't talk about anything that happens inside the DA's office, right?
No.
It doesn't say you can't talk about it?
No. You said it basically says that I can't talk about anything that happens inside the DA's office, and that's not what.
Are you tendering this exhibit? Ms.
I am, yes. We would tender 13.
Ms. Cross.
Oh, he's so good.
Fail to see the relevance, or I'd lodge a relevance objection, but otherwise nothing else.
Ms. Merchant, relevance of this?
Judge, it's relevant to his testimony. If he signed an agreement that says he can't talk about things that happen in the district attorney's office, I think that's relevant to this.
To what?
I also think
How?
How?
that because it's motivation in his testimony. I mean, whether or not he's going to testify to something. It's also been certified. I mean, it's part of the record as from what Fulton County gave us.
Sure, but he hasn't said that that's preventing him from testifying in any way today, is it?
Well, and I can ask him about that.
Okay,
Yeah.
Mr. Wade, is this confidential agreement affecting your testimony today?
No, sir.
Okay. All right. That's fine.
Oh, man.
The contracts judge and the invoices that I wanted to admit all of his invoices and contracts with Fulton County. I have them certified. I guess I have them certified through Fulton County, so I wasn't sure if I needed to do that. I just wanted to know if the state had an objection to those before.
Well, they haven't had, I don't think they've had a chance to look at them. So that's the sole remaining exhibit in line of questioning here?
Yes.
And
Thank God.
in terms of the follow-up questions, would it just be for him to say what's reflected in these documents themselves?
If they have an objection to the certificates that Fulton County has given, I would admit them through him because he could recognize
Right,
them.
but assuming they're admitted, would there actually be anything substantive that he would add other than the documents themselves? All right. Okay, so subject to that qualification, do you have any other questions of this witness?
May I just have a moment?
Sure.
Thank you. Is it possible actually we take a quick break?
We're getting there.
Okay. Thank Thank you.
Yeah, I could use some ice water myself, but oh, good grief.
And we certainly had the opportunity over lunch to take a look at these documents and work out whatever we could.
Wow.
Did you discuss your relationship with Miss Willis in social settings?
Help me understand your question.
Did you discuss your relationship with Miss Willis in social settings?
No, I heard the question. I just need to understand what you're asking me. Like, what relationship when?
Your personal relationship with Miss Willis, unqualified, I'm sorry. Did you discuss your personal relationship, your private, personal, romantic relationship with Miss Willis in social settings?
No, ma'am.
You've never discussed it in social settings?
No, ma'am.
Did you ever discuss it in front of Robin Yurdy in a non-social setting?
No, ma'am. Miss Willis is a very, as am I, we're private people.
And this is none of your business.
Our
Thank you,
relationship
Suburban
wasn't a
Housewife.
secret. It was just private. So not at all. I wouldn't have discussed my relationship with Miss Yurdy or anyone else publicly.
Okay, I actually did have some questions just about the invoices, if we want to just.
These are the documents that you're referring to?
Yeah, they are. It's all of his invoices. I
And
mean,
what kind of questions would these be other than the invoices say what they say?
it just that, yes, that they say what they say.
All right.
Just
any
talk
other
about them.
questions?
That's fine. No,
All right.
thank you.
All right. At this point, we'll take a break. I'll ask the parties to take a look at. What had you marked that as a defense exhibit?
I have his contracts and his invoices that I'm about to mark. So before he leaves me, I just want to make sure that the state doesn't have any objections.
But those are marked as
They're about to be marked. As
exhibit 14.
14, 15, 16, 17, and 18.
All right. So 14 through 18. So I'll ask state take a look at those.
I will take a look at those and see if I can match them up with the certified documents that were presented.
All right. And then we'll address whether they are tendered for the record when we come back. And from there, then we would turn over to the remainder of defense counsel and then the state for any examination as well. So to that end, let's take 45 minutes. We'll be back at 1 o'clock. Mr. Wade, you're still under oath, and I'd ask you not to speak with any other witnesses about your testimony or about any testimony that's already occurred.
Yes, sir.
All right. We'll be in recess.
Oh my gosh. That's the thing. Unbelievable. Okay, let me get rid of this banner. And let's at least check in for a minute on MSNBC. Hang on. Come on. Tap to unmute. I'm unmuting.
This case is dead in the water. She will be disqualified. The case will then have to go back to be reassigned to another prosecutor's office. Likely it will languish there for months. I think it's over. I think the case is over.
But hold on, because why do we think that she was lying at this point, right? The judge has to make that determination. We heard Nathan Wade double down on what he had written in the affidavit and saying that, no, our relationship, our romantic relationship didn't start until after I became the special prosecutor on this case, not before. So you're pretty certain, though, that he's been established as untruthful?
I think everything is pointing in that direction. He submitted an affidavit, he wrote the affidavit, and Fani Willis's office submitted that affidavit. So she's just as complicit as he.
Andrew, if you would, take us on a broader picture of what it is that we've been seeing, but also what are the issues that they're discussing and why are they relevant to the larger Georgia case against Trump and the other defendants, co-defendants?
So going into this hearing, that was the argument that Fani Willis's team was making, which is this is sort of apples and oranges. Even if there's an issue, it's sort of irrelevant to the criminal case.
Right.
So here, the real concern for the judge who said, I'm going to have this hearing, was financial. It was, I want to know, was Fani Willis really paying sort of half her share, or was she essentially profiting from her relationship with somebody on the team who has this contract, Mr. Wade? So it was very sort of cabined to that sort of financial component. One part of that financial component is, well, when did they start having this relationship? Because that helps decide when did money start getting paid. So they talked about taking trips and that they roughly were splitting costs. All of that was by the wayside. In other words, that was sort of going in. That was supposed to be what the main issue is. And I think the main issue now is, did somebody lie? I agree that at this point, just looking at the demeanor, the judge would have a basis to say, I believe the witness who said the relationship started at a time that Fani Willis is on record saying it didn't, and Mr. Wade is saying it didn't. So there's a discrepancy, as Chuck said. We have to see, this is just the start of the hearing. There are other witnesses, there'll be other proof, but I agree at this point, just looking at their credibility, but it's not our judgment, it'll be the judge's judgment. If they find that Mr. Wade lied and thus Fani Willis submitted a knowingly false affidavit, I agree, it's over.
Do you expect that, or Charles asked you, that they will call, in fact, Fani Willis to take the stand?
I think we can see that. I think that we should anticipate that that's going to happen. At this point, it's questionable as to what value that would have in terms of, do you need it? If you're someone who is arguing for the disqualification at this point, I think that you feel pretty good about where you are. I don't necessarily know that Mr. Wade did a bad job in terms of his testimony, but I also don't know that as someone who is clearly interested in this from two angles, both personally with respect to his divorce and the impact that it could have there, and professionally, obviously, as the special prosecutor on this case, those are things that I think put him in a position where his credibility is going to be significantly questioned and challenged, even as he wasn't a terrible witness. I want to point out the lawyering that we saw today, like for a lot of people who may have watched this, they may have thought, man, this was brutal. Yes, the actual subject of the testimony and the substance of it was not the cleanest thing to walk through, but the lawyer that we saw and the lawyering that we saw was not really top notch. It took them very long to get to where it is that they needed to go, but eventually, it seems like they may have gotten there.
Andrea.
Let's bring in MSNBC's Katie Fang, who's outside the courthouse in Atlanta. As a lawyer, what was your take and whether or not to preempt this whole case blowing up?
Is the case
Fani
blowing
Willis,
up?
as Chuck Rosenberg was suggesting, might, as this is proceeding, just preempt a decision and step aside so that it can to protect the prosecution itself.
Yeah, so Andrea, I'm going to go back to the basics. And when I say that, I'm going to go to the law in the state of Georgia. In order to disqualify a prosecutor, Georgia law says that you either have to have forensic misconduct, which is not an issue here, or you have to have an actual, not a speculative or, an imaginary conflict of interest. So is there a conflict of interest? Because that's ultimately what Judge McAfee is going to have to decide. He's going to have to weigh the credibility of the witnesses who have testified so far against each other. Was there some type of disgruntled former employee bias that came from the first witness called to testify this morning, and Robin Yurdy, the former divorce lawyer, Terrence Bradley, who had a brief stint on the stand until he was temporarily excused.
Energy on this.
He's worried about his bar license and disclosures that were made, but he said that Nathan Wade approached him as early as 2015 about getting divorced. But ultimately, we did hear Nathan Wade provide sworn testimony that was completely, opposite to what that first witness said, which was that Wade and Willis began a personal relationship as early as October.
Yeah, but I don't believe her.
The judge is going to not only look at the credibility of these witnesses, but he's also going to look at the documents that are being entered into evidence. But these contracts, the payments that were made, Andrea, to Nathan Wade, they only have an influence on whether or not Fani Willis gets disqualified if she has a personal stake in the conviction of a defendant. But is it personal because she's getting any type of financial benefit? Well, we've heard from Nathan Wade that she's paying her own way. I mean, honestly, Andrea, this has become very messy. It's become a very messy, I think, circus sideshow that has been an unnecessary sideshow for some very serious, very important case that needs to be prosecuted. I think Andrew Weissman said it just a couple of minutes ago. This case started about the financial benefits, but now it's kind of devolved into, did somebody lie in a submission and a sworn affidavit to the court? Perpetration of fraud upon the court is not only wrong, but it certainly could rise to the level of disqualification. But I don't want anybody to put the cart before the horse. I think we need to listen to all of the testimony in its totality, and we need to remember the law before we make any judgments ourselves.
the courtroom. Take us in, talk to us about the demeanor of people. There was a moment that the judge actually chastised somebody. I think it was on the side of the defense. What was that like in there?
Yeah, so Jose, David Schaefer, who's one of the co-defendants, when Nathan Wade testified under oath that Fani Willis has reimbursed him for trips that they have taken, and she reimburses in cash.
I'll try to. I probably overloaded counter. That's it. That's maybe that's the problem.
Immediately rebuked him and said, "If you do it again, if you're out of
Let me
my
see what I've
courtroom."
got here.
McAfee is trying to walk a tightrope right now, like a really fine line between trying to get the evidence that needs to be on the record in this evidentiary hearing, but also trying to make sure that they don't veer too far. Of course, as a lawyer, I think that the judge can maybe rein things in a little bit more. I think some of the questions by the lawyer from Michael Roman of Nathan Wade has gone a little bit too far astray and maybe a little bit irrelevant. But, you know, it's her burden. It's the defense's burden to be able to carry this motion to disqualify. And I think that's the reason why Judge McAfee is giving them more leeway than perhaps I would.
And Katie, what about the appearance of a conflict? I mean, what about Chuck Rosenberg's comment that just the appearance of a conflict could really prejudice the public against this case and the future of the prosecution?
Andrea.
Yeah, so Chuck is totally right. I was a prosecutor for many years as well. You want to avoid the appearance of impropriety. You want to avoid the appearance of a possible conflict of interest. But in this instance, as I noted, Georgia law doesn't allow for the possibility of that conflict. It actually has to be an actual conflict. That being said, we all know that this case is also being tried in the court of public opinion. Is there too much credibility damage that has been done so far? Would it save and resuscitate this case if someone else stepped in? In Georgia, if DA Fani Willis is disqualified, it's her entire office. It's the team that is gone. And then there's another council of prosecutors that would decide which office takes it over. The problem with that is that that new office could decide, you know what, some of these charges don't fit. Some of these charges aren't strong enough. We're going to have to reevaluate where this goes. And so that not only puts a delay in bringing these defendants to trial, including former President Donald Trump,
I'm
also
going
makes
to
you wonder what's going to be left if Fani Willis gets disqualified.
I'm going to take this out of my ear for a second so I can focus on the reading.
Does it require, if she were to step aside, bringing a whole new office in, starting over, examining whether RICO even should apply here? And whether all of these co-defendants should be involved.
As Katie said, if the judge disqualifies District Attorney Willis, then the entire office is disqualified. I think there's a more prudent approach, perhaps a more practical approach. If Fani Willis simply steps aside prior to a judge's ruling, that may mean that the case can stay in her office, but not under her supervision. And by the way, Katie is exactly right about what the law requires. But I've always thought that prosecutors ought to go beyond what the law requires, particularly if there's an appearance of a conflict. It may not technically require a disqualification. We will see how the rest of the evidence comes in. We will see who else testifies and what documents they adduce. All of that's important to the judge in making his determination. Hasn't happened yet. But that doesn't mean that Ms. Willis can't act now on an appearance of a conflict. We've learned as prosecutors that appearances matter just as much as what the law requires, right? I mean, we have to be two things as prosecutors all the time: actually fair and perceived as actually fair. If you're actually fair but you're not perceived that way, that's a problem.
And of course, this is such a high stakes case. Just one other quick point. Nathan Wade would also, of course, have that they would have to step aside voluntarily if that were the case. In this issue, among the issues, has been whether he was even qualified to play this role. And the argument was...
Yeah, I'm not listening to Andrea Mitchell. I'm just not. I don't like her. I don't think she's a good journalist. That's my opinion. Anyway, okay, what I am getting is that I'm just going to call it the MAGA side. So those who are gosh, I've got so much. Hello, everybody. I'm trying to juggle a little bit too much right now. Okay, I'm going to turn off auto exposure and turn this up so you can see the cards. Hello, everybody. Hi. How are you doing? How's it going? All right. So I'm just going to call the Trump side. So Roman and all of these people. I'm going to call these people, I'm just going to call this the MAGA side. Okay. So that's what I'm referring to, right? These are the people who arrested. They all have inmate numbers, which I think is glorious. But anyway. All right. So they're desperate. Their case is weak in the situation they were in the first place. So somebody heard a rumor that there was a relationship, and they have tried to turn this into a whole parade, even though it's and that's the thing. If you want to disqualify Fani Willis or Nathan Wade or any of that, did she lie about when the relationship started? Define the relationship. Maybe it was more of a booty call. Maybe it wasn't a romantic relationship, and she wasn't benefiting from it financially. You can't blow up this whole case because she had booty calls or the occasional lunch or friends with benefits. Friends with benefits isn't a relationship, isn't a romantic relationship. Anyway, in the past, Page of Pentacles. All right, let me see. The center of the reading, Knight of Cups. Actually, I wonder if I can tilt this down just a little bit. Like not a lot, but some. All right, do this. Okay. And I can turn on the. See, I can turn on that, but it's very small. I can turn on the closed caption, but it's tiny. Anyway. So the center, Knight of Cups. This is Willis and her team going after Trump and these cretins. All right, hanging above the reading. They're coming after her. There's a whole lot of temperance here. This is a whole lot of, fury. Oh my gosh, duck, kind of. And this is a whole lot of no. So there's both of this energy hanging over this. And at the base of the reading, they're trying to hem her in, and there to be judgment. And this is kind of where the energy is going weird, because it's judgment, and there's all kinds of judgment. Some people would say it was bad judgment for them to have a relationship. Who cares? Who cares? 2, it could be judgment from McAfee. It could be judgment of the public, whether or not she gets reelected. It could be a lot. So, home environment, center environment is, I keep getting this card, and it feels like this is not a huge amount of money. You have to prove that she benefited. Goral says many readers get that the ex got paid. Will that come out? Could be. Could be. This is just not a lot of money. All right. Hopes and fears. Well, we don't want the case to blow up. We don't want the RICO case to blow up. And by the way, this is just a hearing. She's not been charged with anything. So, hopes and fears, what other people see. Patriarchy, going after a single man and a single woman, professionals of color in a very patriarchal system. And if they were white, would it matter? Honestly? I mean, Trump would probably still go after them, but I'm sorry, but nobody can tell me there's no racial bias going on here. I'm just not buying it. All right, the challenge. Well, the challenge is if it all goes really wrong, would she be removed? Okay, near future 1 and 2. Near future 1. Oh, the merchant, her people, they're setting this up like they're going to show it with they've got a smoking gun. I tell you, smoking gun, waiting for their ship to come in, and working. What do you mean working? Don't you mean, shouldn't this be evidence? If you're waiting for the ship to come in, shouldn't this be evidence? When your ship came in, not more work. Why is it more work? What about your slam dunk case? You're at this hearing. Final outcome 1, 2, and 3. Final outcome 1. Final outcome 2. Final outcome 3. Confusion. Define what is a relationship. I keep getting that over and over. What is a relationship? You want to prove that the district attorney lied about when a relationship started, a romantic relationship started. What's a romantic relationship? Do you want to go through did they go to first base or second base or third base, or was it a home run? And Wade got up there and basically came across as someone very respectful. Let's see if I can get anything else, but let me use cards I haven't used yet. See if I can get any more information. You know, these people seem very convinced that on MSNBC, they seem very convinced that that's it. The whole case is going to blow up. That Fani Willis lied and all this kind of stuff. I'm not getting that. Oh, that's absolutely absolutely correct. Suburban housewife. They're trying to smear Judge Goron and saying that he's had an affair with the law clerk who helps him. They have no proof of that at all. So, okay, CC Ryder saying Weissman is making leaps. I have a ton of respect for him. I've traveled with men friends, stayed overnight with no relationship, then changed a year later. Fran is saying, I honestly don't understand why it would be any of their business what goes on between adults. It's the idea of, at first it was, did she benefit financially? And now that's looking weaker, she paid stuff back. She's an independent woman. Now they're trying to say, they want to prove that she lied under oath about when their relationship started. And I'm saying, what's a relationship? What's a romantic relationship to you, to me, to this hedonist I know, to what's a romantic relationship? No Flowers and Stars asks what's happening in the Stormy Daniels case, the Bragg case. I don't know. Someone please let me know. Georgia case. Okay, Georgia case, right? I pulled cards. On the defensive, feels like they're right on the defensive. This is all minor arcana. This is weak sauce. I wanted some clarification on that last thing. I know what they're saying, but Electra Storm. Thank you, Valerie. Thank you. Oh, and hello, Sarah. How are you doing, my friend? Thank you. They're going to start jury. I heard that they were going to start jury selection on the 25th, but I didn't know if there was something else that had come up. All right, let's see. What are they saying?
MSNBC's Yasmin Vasugian, who is outside the courthouse here in New York City. So, Yasmin, what else did we learn from today's hearing?
I tell you, the trial got up and going, or the hearing, I should say, got up and going around 9:30 this morning. By 9:35, 9:40, Judge Marchand had said motion denied. The motion to dismiss the case by the former president and his attorneys was, in fact, denied. And then a couple minutes later, he said March 25th, he was setting the date for the trial. The former president's attorney, Todd Blanche, speaking a lot about how he felt as if this was unfair, right? He made the argument that we were in the throes of the primary season. The former president had to be out on the trail as he was running for re-election as president of the United States. And that didn't necessarily land well, I'd say, with the judge guys. I will also say,
wow, it's almost like Trump having a real job.
Making the argument that this date was better than any other date because no other date had been set. There had been coordination, the judge said, between both him and Judge Chutkan down in D.C., and she had reiterated to him that no date had been set for the D.C. case. Hence why March 25th seemed like it was the best date to be having this case move forward. I will say what also I found interesting was the questions when it came to the jury selection, right? They had to submit both questions for jury selection, both prosecution and defense. And there was a lot of back and forth on this. Some of these questions that were posed from the E. Jean Carroll case. And much of it was getting to the heart of political affiliation of these jurors, right? Some of the questions that were being asked essentially of these jurors, or that will potentially be asked of these jurors, are, what is your political affiliation? Where do you get your news from, for instance? Are you getting it from CNN? Are you getting it from MSNBC? Are you getting it from the New York Times? At one point, the prosecution asked that they add, for instance, to that, are you watching kind of more far-right leaning media outlets?
All right.
And Todd Blanche came back on that. They also wanted to see if there was any kind of affiliation with any far-right groups as well. Whereas Todd Blanche kind of came back
so
on
I'm
that
going to
as well.
stop this.
So there was a lot of back and forth. If we're looking at
All right, so that's going there. I'm going to call it on this stream. I'm going to take 10 minutes. I've got to get on the regular stream, and I need to get on the regular stream, and I need some ice water and whatnot. So I'm going to go over to the regular stream for today, but thank you. Thank you. If I'm five minutes late, I apologize. I shouldn't be, though. But like I said, I really need something to drink. And yeah, all right. So thank you for watching with me. I'm just very confused because I'm worried because the pundits are saying, that's it. But the cards are not. And I don't understand the logic, but I could be wrong. Of course. I do not believe anyone who says they are 100% correct, frankly, about anything, but certainly about reading on the collective energy. But I don't get it. But okay, we'll see. We'll see what happens. All right. Hang in there. And I will see you shortly on the regular noon live stream at Black and Orange. Thank you. Thank you. And thank you for the super chats. It's huge. Huge. Thank you. Oh, thank you, Foggy Ozark. Thank you for trying. Thank you. All right. See you in 10 minutes, 15 the most. Okay.